Welcome to the European Data Summit, including to our audience participating per live stream. My name is Pencho Kuzev. I work for the Department Politics and Consulting of the Konrad-Adenauer Foundation, and I'm going to navigate you through this event in the next 3 days. My special welcome to our European guests who, despite corona restrictions, have arrived in Berlin and even provided negative corona tests on site in order to join us. We're so grateful for your participation. Many thanks. Now, I would like to invite Professor Norbert Lammert, the chairman of the Konrad-Adenauer Foundation and the former president of the German Parliament, to open the 4th European Data Summit. Professor Lammert, the floor is yours.
Thank you, Mr. Kuzev. Good afternoon, ladies and gentlemen. It's a pleasure for me to welcome you and to open this 4th European Data Summit of the Adenauer Foundation. And I thank you for your interest and your participation. We are a bit proud that during the last years, this conference has established as one of the prominent formats for exchanging informations, experiences, and initiatives in data policy making. And this is a sufficient reason to thank all the experts, the speakers who made this conference as promising as it is. And this is particularly true for the forthcoming conference, but I would like to include all the participants of the former conferences as well. It is nearly self-understanding that and why a political foundation like the Adenauer Foundation deals with this subject. Because we are dealing with politics. And politics has an unavoidable multiple interest in data. It deals with data, with informations, with fakes, with messages, with comments, with speculations, all that having some influence in policy making. Secondly, it sets framework conditions for dealing with data. By the way, even if it doesn't set framework conditions, it sets framework conditions. Avoiding to give regulation is some kind of framework condition. And one of the sensible points, not only for this conference, is precisely to which extent there is a need for regulation. And thirdly, politics at least reflects sovereignty. It has to do with the claim of sovereignty. What does this mean in terms of data policy making? Does digital sovereignty exist at all? And if so, what about Europe insofar? Do we have a role, and which one? Do we have any significant influence on framework conditions in dealing with data? The European Union has decided to introduce instruments to give its citizens more control of their data and impose regulation, at least on major significant gatekeepers. The approach of the European Union to do so in terms of a Digital Markets Act and a Digital Service Act is the attempt to maintain at least a remarkable influence in digital policy making. To make remarkable players at least more responsible for what happens on their platforms. The Adenauer Foundation has published a study, Restoring Balance to Digital Competition, about a year ago. And we gave some information on lacks of regulation and to overcome the regulatory time lag and enable authorities to react more quickly and more efficiently. Let me remind you on some historical dates which in my understanding had something to do with our subject today and during the 2 following days. On December 1st, 1989, precisely 30 years ago today, the East Germany's parliament at that time abolished the existing constitutional provision granting the Communist Party the leading role in the state. There was no competition until then, politically, over 40 years. Not even to speak on fair competition. There was no competition at all until this date. There was no distribution of power. There was no sovereignty, neither sovereignty of people nor sovereignty of data. And again, precisely 20 years later, on December 1st, 2009, 12 years ago, the Lisbon Treaty entered into force. This is the common framework of the member states of the European Union expressing their understanding how to deal with each other, defining minimum standards of competition, of distribution of power, of sovereignty, of responsibility. And there's probably no other field which has more influence on this minimum standards being implemented or not in a modern society than the field of data. So we are in the heart of urgent issues within Europe and beyond Europe. And once again, I express my gratitude to all participants, all speakers who contribute with their experience to necessary initiatives during the next months and years. And I also express my congratulation to the colleagues of the European Parliament, particularly to Andreas Schwab, the rapporteur on the respective European initiative, the proposed Digital Markets Act, for successfully concluding the procedure within the European Parliament, which is not already the end of the story, but a major necessary step in implementing our aims in so far. So once again, welcome, and I look forward for once again an inspiring conference which, given the experiences of last years, opens not only doors for remarkable academic research, but for political implications, which is a particular interest of a political foundation. Thank you for your interest and welcome once again. And now I deliver the floor to Andreas Schwab, hopefully being connected with us in Brussels.
Absolutely well connected. Thank you so much, Professor Lammert. Thank you so much, Mr. Kutzev, ladies and gentlemen. It's my pleasure that we can do that tonight via PC as an online format. I was last year with you in Berlin. I have a very positive memory on this. Unfortunately, this time we are distant, but I think the topic is that important. And I'm very grateful for lots of you that have been following the developments, that I feel a lot of proud and pride that I'm with you today again. Because as Mr. Lammert has mentioned, and as a former scholar of the Konrad-Adenauer Foundation, I'm very proud that you have taken the leadership for discussions for the organization of such a conference to exchange and to assess about how open our economy is in the 21st century under digital conditions. And I think Mr. Lammert has rightly referred to history. I always refer not so much to the 1st of December 1989, which is a very nice example that competition in history always has to be reassured, has to be confirmed. I refer all the time to the introduction of the social market economy principles in the Federal Republic of Germany in the 60s of the last century, which have taken into consideration all the negative effects of an oligopolistic part of the German economy in the 20s, which has also led our democracy in Germany to be falling apart because economic interests that were too dominant have in the end not allowed for democracy to make its real choices. Because they have allowed the Nazis to come to power, although they never had a majority. And therefore, I think it's so important for us in Germany, and we share that with our European neighbors a lot, that the more open an economy is, the more open also a society can be, and vice versa. And therefore, we have to make sure, and we will do, and I will outline how we do it at the moment at European level. We want to outline that our principle of the Western societies in Europe is openness, democracy, fairness, and the possibility for opportunities for everyone. Like that, we give to any citizen the chance to feel ownership in an economic sense, but also in a political and a societal area. And this is of utmost importance for modern societies in the 21st century. I would like, because last year we had already the chance, ladies and gentlemen, to discuss a bit about the pros and cons of the proposal of the European Commission that was just about, I think, to come out, or maybe it was already on the table in December of last year. This year we can, and I'm very grateful to all colleagues that have contributed to this. This year we can already consider the text as it has been voted in committee under my leadership. And I'm very happy that it has been possible in quite a fast time to move this file to the plenary vote on the 16th of December. And we do hope that by the end of March of next year, we will have this text finalized. So the Commission has presented quite good proposal that was in a lot of areas very well thought through. However, it was also clear that some changes are needed, were needed. And these changes that I thought were needed show also a bit what the European Parliament, what me as a rapporteur, I would say we have achieved. The most important point with that regulation is that it's quite a heavy regulation. It's quite bureaucratic because it sets rules that companies have to respect and apply before even they start their business activity. Normally in a modern market economy, we want to try the utmost to put away red tape. so that companies can grow and flourish easily. Here, in a certain sense, we do the inverse. And I think this is a difficult decision for politicians because we see how much innovation digital companies can bring to our societies. We see how much connection can be created by intelligent and fair platform work on news and media. But we also see that if things are not going 100% in the right direction, there is a big risk of putting democratic societies in a difficult situation, and that's in any event what we want to avoid. Therefore, I think we have been happy to achieve a much better focus on that law, applying only to the very large platforms. I would have even loved to have a even higher threshold and even more precise scope of this regulation, because based on market capitalization, we are in a very dynamic area, and what we define today as the threshold will already be 10% higher in 1 year, because digital markets, digital companies in capital markets are growing that fastly that probably we are still a bit too little. But in any event, we were able to shift from 65 to 80 billion as a threshold for gatekeepers to be designated. Secondly, I do believe that this regulation has achieved to make everything possible to put the European Commission, the European Regulatory Authority, on the same level as the gatekeepers, at least technically, at least as an authority, because in manpower, the gatekeepers are by far bigger. I have just learned some days ago that only the legal department of the company Apple has more than 900 people, whilst the European Commission's digital market unit or director general in the future will have around about 80 people. So not even 1/10 of one of the gatekeepers will be the manpower of the European Commission. And therefore, it's very important that the European Commission can speak to the gatekeeper at the same level, at arm's length, and can impose the rules that the lawmaker will now vote for. That means that we have made easier the application of structural and behavioral remedies. We have made easier the application of do's and don'ts in Article 6 and 5. And also we have created an anti-circumvention clause, which should make easier that these rules can be applied with strength and authority. And then the third element that I would like to mention is that also we made clear that although merger policy and competition policy at European level are based on the principle of unanimity, that with the DMA, there will be also a need for the European Commission to make sure that mergers of gatekeepers fall under an element of closer eye, are considered more seriously, because we don't want to see the bigger always getting bigger without getting better. We want to very clearly say game over to unfair trading and business practices that are just there to capture the market without bringing advantages to the users. And like that, I think we can really believe and make sure that we do good to the European, but also to the worldwide economy, because in the end, what Europe will do in the area of digital markets, as we did already with the General Data Protection Regulation or the NIS Directive, Network and Information Security, these are tools, as the DMA will be, that will be taken up in other countries of the world, because a lot of countries like Japan, for example, or Indonesia are looking to Europe and want to see how we deal with that difficult question of making digital markets fairer and more competitive. And therefore, I believe that we have a unique chance as European Union to create something to make the life in the world better, to make the worldwide economy more competitive, and therefore also bringing more results to businesses and a better environment to consumers. And that's in the end, and Mr. Lammert has referred to that, that's in the end the sense of policy. We are not here to wait. We are here to act, to improve the world, to improve the life, to improve the economy in the interest of all our citizens, not only of the rich ones, not only of specific ones. We are here for everyone to defend the principles of the freedom and Western democracy. And therefore, I think If we manage to keep that together, as it seems at the moment, the proposal of the European Commission is a very good tool to fight unfairness in digital markets. And with that, ladies and gentlemen, I would like to close this short keynote. I will not speak to you too much about details. Maybe we'll pick them up in the debate. It has been a pleasure for me to participate again. And I would like to thank again the Konrad-Adenauer Foundation for a very strong leadership on this question of how strong we can fight for openness and fairness in digital markets. And it's my pleasure to be with you. Thank you very much.
Dear Andreas, many thanks for your overview. I think there were quite dynamic days behind you, and I believe that we're going to have a success in the coming weeks, and we are going to adopt finally the DMA during the French presidency. I have one question for you from Louis Crofts from Emilex. Would you have a couple of minutes for us? He would like to know, where will be the main battlegrounds in the trialogues on the DMA? Which areas will need compromise?
Well, it's very difficult to speculate at that moment in time about what problems may come up in trialogue. Obviously, the European Parliament is in a very positive situation, in a very good position, because we don't need to close this by the end of March. This is the French presidency who wants this, and we are supportive of it. But we also want to make clear that we have gone through that proposal with a lot of seriousness. I think all my colleagues in the Internal Market Committee and in the European Parliament in general have been looking very seriously of what can be achieved and what we should better not to try in the DMA, because there are also other laws that will come later, like the Digital Services Act. And therefore, we will defend all our positions that we have taken. We will defend the scope. We have to focus on bigger companies. We will defend the rules in Article 5 and 6 that are very tough. We will defend also the move to have a better look on mergers in digital markets. And we will for sure also defend the European Commission's role on interoperability that can be imposed and has to be improved, and on the application of General Data Protection Regulation, also as a tool of the Digital Markets Act. Because what we see is that there are 2 or maybe 3 companies that just collect all the data in the internet and sell it to others. And this movement is a one-way street, because there is no competition here. There are 2 competitors that have shared the market in between them. And all this has to be fixed with the DMA, even though there might be national authorities, national competences at stake. We have to do that out of one hand by respecting for sure the important role that national authorities have been playing and will also play in the future.
Thank you very much. Maybe the very last question. Professor Lammert mentioned that we have published last year, and you remember we have discussed the study by Marsden and Podzun, Restoring the Balance to Digital Competition. We've learned that yesterday there was a compromise for the Data Governance Act. That's also great news. What do you think? Is the DMA going to restore the balance to digital competition in 2, 3, 4 years? Your opinion on this?
Well, there are 2 elements to fair competition in digital markets. One element is the enforcement of the rules. And here we have to admit that, unfortunately, we are lagging behind, because we see that, for example, on advertisement, the data protection rules that we have made already years ago are not applied in the way it should have been done. It was thought to be for the big companies, but we have been ending up at the beginning by limiting the outreach of of WhatsApp groups of parents for data protection reasons. That was never the aim of the General Data Protection Regulation. The aim was to fight the misuse of data by the big companies. Therefore, this time it has to be better. We have to focus clearly on the real problems and not run the slippery slope of relativism down to applying it all over the place. The DMA will be applied only to the biggest companies in the market and not to everyone. So enforcement is a very important element. And here the European Union, the European Commission on one side, and the member states have to work closer and better together, because we are unfortunately seeing that we are not there where we would like to be. And then there is a competition element also in legislation. And here I think the ex ante rule that we introduced with the Digital Markets Act has for sure also some risks. But in any event, it will allow for regulators to impose the rules at a very early stage, and it will change the burden of proof from the authorities to the companies. That is something that will make authority decisions much better, much easier, much faster. And like that, I believe that in 2 years, competition will be already much better. And we see that these companies are already ahead of our laws, trying to apply them, because they know if they don't, they will face difficult times. And therefore, I think it's a very good proof that if the legislator does its job, it can impose the rules also for digital markets.
Many thanks. I think when it comes to enforcement, you're talking too hard to Johnny Ryan, who is with us today. Many thanks for your time. Hope to see you next time in Berlin, and wish you lots of success in the coming weeks when it comes to DMA. Many thanks.
Thank you so much, Mr. Kutzev.
Ladies and gentlemen, we are continuing our program for today, and with our next keynote speaker, which is Dr. Johnny Ryan. Johnny Ryan is a senior fellow at the Irish Council for Civil Liberties and a senior fellow at the Open Markets Institute. He is focused on surveillance, data rights, competition, antitrust, and privacy. And his previous role includes Chief Policy Officer at Brave, Chief Information Officer at the Irish Times. He's author of, I believe, many books and cited in the New York Times, Die Zeit, Economist, Wired, Le Monde. Some call him the Google's biggest irritant, I believe, or in German, Google's größte Nervensäge. And we are really happy that he is today with us. Dear Johnny, the floor is yours.
Thank you. Thank you very much. Thank you very much. I've made the mistake of wearing one of these microphone things and a face mask, and then trying to remove the face mask and fidgeting with it. So I'm amazed my microphone works. Let me start by thanking you for inviting me and just give a bit of background. Up until about a year ago, I was still working in the industry. I was working for an American tech firm, a startup, backed by Silicon Valley money. And the person I was working for there was the individual who had invented JavaScript. And our project, and his project still is, to try to make a multi-billion-dollar business from privacy, from bringing people privacy. And I wish him good luck. Before then, I've had roles in tech and in media, including online advertising. So the background I bring to this is a cynical and yet optimistic one. This is the title, and it's my title, I proposed this, but this is the terrible title that I agreed with Pencho to speak about today. And so bad is this title that we're going to get rid of it, Pencho. We're going to break all the rules. If there's a way to make those slides bigger, you've got a beautiful big screen here. It'd be great if you could use it. So bad is this title that we're going to scrap it. Maybe you could make that screen bigger, tech people, bigger. If you can do that, that would be great. I want to reform this title because I think the problem that we're discussing on these 3 days can be summed up in 3 words. Sovereign, yes we are, but we're impotent. We have all the tools, but we don't use them. So this idea about a regulatory superpower, well, first, what is a superpower? We in Europe, not necessarily I in Ireland, but we in Europe do not need to look too far to know what a superpower looks like. Here is a map from 110 years ago, showing trade routes. My God, you've crucified my slides. Here is a map showing trade routes, and you will see all of those routes bring stuff to Europe, because Europe from the 16th century to the 20th century was the superpower. And the idea we had was that we could now be a soft power superpower, a regulatory superpower. So in May 25th, 2018, we introduced the GDPR as effective law. It now is being applied. It's not just the 2-year lead-in period. And from 2016 on, more than half of the world's GDP and far more than half of the world's population introduces or begins to introduce a GDPR-like law. So we have actually that soft regulatory superpower effect, but that effect is cooling. When I was working in industry, what people wanted to know in the US was, are the Europeans serious about this GDPR thing? I gave them the wrong answer because I believed it. I said, yes, Europe is serious. It means business. It would not be talking about the GDPR if it weren't serious. It would be too damaging to its credibility if it weren't serious. And let's think about the stakes of not being serious. We've got 4 problems, at least 4 big digital problems. Privacy, our markets are in total disarray. We've got a competition problem. We have a disinformation problem. And we've got an algorithmic harm problem. And that last one will get worse. So let's gaze upon these 4 horse persons of the apocalypse and get a vision of what our future is going to look like if we don't get our act together. Now, the one area where we've had any degree of what we might claim to be success is competition. And when we look at competition, we look at big fines. We clap ourselves on the back as Europeans and we say, look what we did, we imposed these fines. Well, let's put that in perspective. This is what perspective looks like. That's a single year. So when you think about sovereignty and whether we have it, let's not kid ourselves. And the reasons why we don't have it is that we don't get it. Dare I say they don't get it, but we don't get it. If you are working in the competition domain and you're trying to understand what data are and what digital are, it's hard. And sometimes when something is hard, it is well worth trying to find the smallest little thing from which the complicated thing grows. We need to abstract ourselves a little bit and get a grip of this digital thing and really understand it. So bear with me, we're going to go on a tangent to 1665. This is where we start, maybe, to get it. This is Micrographia. It's a famous manuscript written by Robert Hooke in 1665. Hooke was one of the founding figures of the Royal Society, one of the parents of the scientific moment. Now, what Hooke does here is he takes one of his inventions, his beautiful microscopes. He used to grind his own lenses. And he shows humans things that, although they'd lived in a room with them for somewhere between 1/4 and 1/3 of a million years, they'd never seen them up close. This is Hooke's sketch, and humans had never seen it, of the eyes of a fly. 1665, the first time humans see this. But it's also in Micrographia in 1665 that Hooke gives us the cell. The cell. This is the cell of a piece of cork, the first time it's ever been shown to human eyes. Without the cell, you do not get biology. You don't get modern medicine. So we need to get the cell or the atom or the quark or the smallest unit of account of the use of data. What is the atomic unit of data processing? There's no point, I think, in analyzing big tech mergers if you don't even have a unit of account of the use of data inside these organizations. Now, if you're progressive and you're in the competition field, you'll talk to an engineer, and the engineer will tell you about Claude Shannon from the 1950s, who invented this idea of the bit or the byte. That's the wrong answer. That's the unit of account of what information are, not of how they're used. The unit of account of the use of information is the processing purpose. The processing purpose. Now, this idea, purpose limitation, goes back to the 1970s. There was a panel of very wise people who had to report to this gentleman, Caspar Weinberger. He was Secretary of Health, Education, and Social Welfare, and something else, which suggests that that administration cared about none of those things. In any case, this panel was reporting to Weinberger, and they were reporting about a problem of magnetic tape. They had magnetic tape, which meant persistent records that were easy to read forever. And they had social security numbers and medical records. And these three things together were potentially going to cause a privacy crisis. So this panel reports to Weinberger, and they say something very simple. One of the things they say is, if data are collected for one thing, they should not automatically be used for some other thing. It's such common sense, you can imagine explaining it to a child and the child understanding. Now, this idea is alive and well in Article 5.1b of the GDPR. It's in the previous directive as well. So let's take a look at what data actually look like inside an organization. Behold, in all their glory, this is what data look like. Now, if they're personal data, they should be ring-fenced. That's what this idea is. And they are ring-fenced by scope. The case law of the ECJ, the European Court, says where one purpose ends and another begins is defined by what I could reasonably expect when I handed over the data. So clearly, different processing purposes have different sizes, different scopes. And you can imagine having a table of elements of processing purposes. Now, if we go back in time and steal from Robert Hooke his beautiful microscope, and we look at Amazon, for example, this is what we should see. Even if it's the same data, it's fenced off, it's ring-fenced away. Even the same data is ring-fenced away. But let's imagine that Pencho and myself start a company. And our company is going to deliver pizza across Europe using drones. It's a very innovative company because Europeans love cold pizza. Now, we start this company and we've got some of this data to deliver your pizza. So we need your Visa card and we need your home address and we've got various other things. And Pencho, who is very innovative, says, I've all of these other things that I could use that lovely lady's data for, and we could make money off of it all. And I say, you're the best co-founder ever. Let's use her data for all of these other processing purposes. Now, this is the organizational big bang. This is what made Google, Facebook, Amazon, those companies so dynamic. And once upon a time when I worked as Chief Innovation Officer for a newspaper that was over a century and a half old, this is what we did not do. So this is the image of the future, but there's a problem. And that problem might be a good thing. Any enforcement of that purpose limitation principle would be like a heat death. In fact, it would be like the undoing of the Big Bang. And the reason these companies are so dynamic is the reason they are so amenable to enforcement using purpose limitation. They have all of these processing purposes, and very few of them are even remotely lawful. Right? That's a claim that is not, I think, too difficult to back up. So here's how this works in slightly more practical terms. Pencho and Johnny now are delivering pizza across Europe, and 300 million European adults are putting on a lot of weight and eating a lot of cold pizza, and we grow on the merits. In year 2, Pencho says, let's get into the ride-hailing business, cars, taxi delivery. And I say, Pencho, you're the best. So we take all of our data about who eats together, where they live, credit cards, single sign-in. We dump it all into the, ride-hailing business. And we don't actually need to get big in the merits. We're just big. Bye-bye, mom and pop shop taxi companies all across Dublin suburbs. And because that works so well, we do it again. And we do it again and again. Now, this diagram could have been used by Andreas Mundt and the Bundeskartellamt in their Facebook case. They easily could have used this because it's pretty much the same case that they've made against Facebook, except, against Facebook. Animation, my fault, comes in late. Except what the Bundeskartellamt doesn't look at, yet anyway, is that inside each subsidiary within the conglomerate, there are different processing purposes, and so it isn't just about cross-using data between subsidiaries. They're cross-using data within the subsidiaries, which is also unlawful, unless they have a legal basis. So the market actually looks more complicated. And now to make it really practical, and you're going to have to squint because we're going up to the top corner here, let's imagine that you have now spent €980 on a beautiful new Android phone. You've just done that. Let's imagine. you will be nudged to sign up to a Google account. And you'll scroll through a whole lot of stuff. Ugh. And the last thing you want to do when you reach the end is not click that blue button, which I'll read out for you. It says create account. But let's say you decided not to click that button yet, and you clicked more options, which is what this says here. Now that is quite some euphemism. We're about to click more options. Now we get web and app activity, which is exactly what you bought the phone for, right? This is also a euphemism. Here, impossible to see on the screen, but I'll try and show you. Here, we've got 3 important sentences. The first sentence says, we're going to save your activity on all websites and apps that Google owns. We're going to cross-use everything, put it into a big bucket, stir it around, use it however we want. The next sentence says, we're going to take all of your stuff from sites and apps that use Google services. Now, let's take it to an extreme example. Nearly every website loads Google fonts just to load the font faster. So the implication of that sentence is potentially limitless. And the final sentence basically says we're going to put this all into a big tub and stir it around and just smear ourselves with it. That's what the terms currently say. And to make sure that these are completely unlawful, I mean, they already are, but to make sure they're completely unlawful, not only are they hidden behind a euphemism, but they're pre-ticked by default. Now, what that means is that when you've bought your phone, this is what happens. You sign into your account and automatically you're in everything. Now, if we allow this situation to continue, what will happen is, in market 1, maps, I'm taking Google as an example of a general trend. Many companies do this. But in market 1, maps, let's imagine that you can know that I am a gay Christian German with a hearing impediment. And you can know that because I go to the audiologist, the ear doctor, I go to a gay bar, and I go to a church. Right? So you know that I do those things every day or every week. Just by my location, you'll know those things. In market 4, where your business as Google is to show ads on other websites and apps. So I used to work in the Irish Times. Google would be providing the ads, for example, on an article there. Google can use the information it has learned from market 1 in that market. And now, when we get to market 5, where Google is showing ads at a much higher margin on its own properties, it can use everything it's learned, not just from market 5, but from market 1 and 90 plus, actually, other markets. So purpose limitation, it does this. It means you cannot actually cross-use the data. That's what the law is today. The law says there is a functional separation. I'm going to go way over time by about, not way over time, maybe 5 minutes, I apologize. Before we get to the end, I'm going to bring you back to HAL 9000, who is the psychopathic computer that kills the astronauts in 2001: A Space Odyssey. Because the image I want you to have in your mind is of the use of purpose limitation, exactly as the surviving astronaut does, to pull Facebook or Google or Amazon's brain chips as they slowly go insane, right? As they're useful to you only for the reasons you want to use them. This is true sovereignty. We did this. On the 25th of May 2016, we made this law. Europe is already sovereign, so why is it impotent? We have big tech kryptonite already in law. So what's the but? Well, unfortunately, here's the but. When you take a look at our latest statistics, which are the first 3 years of the GDPR, we released this report in September, at the cross-border, so major case complaints in Europe, by far the majority go over to Ireland. And that is because when you look at a map of Europe and where these companies have their European headquarters, as you know, a lot of the big ones are in Ireland. And that means that the question of whether Ireland is actually handling these things and processing them is existential. So here is the case backlog from May 2018 to May 2021. Ireland obviously has more cases than others, right? So this might be fair. Here, however, is the percentage of cases delivered. we have a problem, and we know where the problem is. And it's not just Ireland, by the way. We know where the problem is. And it's not just Ireland. The problem is in DG Justice. When a member state fails to uphold its responsibilities, it is the Commission's duty to take it to the European Court. Why has the Commission not done that? Now, that's a question we asked on Friday when we went to the European Ombudsman, who is a woman, and said, please ask the Commission why it has not even equipped itself with accurate data to know whether this law is being enforced. So I want to come back before I finish to this idea of sovereign but impotent. We are sovereign, we built the tools, we're not using them, and we know how to fix that. The Commission can fix that right now by, I think, taking Ireland to court. But I have a letter in my inbox that I got about an hour and a half ago from the relevant commissioner, Didier Reynders, in which, hang on, I'm going back forward, not backwards, which is par for the course, it's perfectly appropriate, in which I have this strong sense that he does not share the feeling of urgency that I have. He essentially writes back and says, let's wait and see, it all seems to be going fine. So, this leaves me with a comment about the Digital Markets Act. Maybe we need a DMA. There are good things in the DMA, and it's good to have them. But if this commission expects the next commission to deal with its legislation the way it has dealt with the last commission's GDPR, there's no point in having any legislation. Why have a new generation of digital law when you cannot bring yourself to get current law enforced? And at the same time, before I conclude, let me say also that there is a very dangerous problem in a very important part of the DMA. DMA 5.1a says something very important. It says, thou shalt not combine data. And I agree with that. That's already law, in fact. But it also says, unless the end user has been presented with their specific consent. So while the GDPR already says, thou shalt not combine data for purposes, this now says, but now we're giving you accidental ambiguity so that when I've clicked that OK button, somehow it's magically OK. So we not only need to enforce the law we have, we need to remember it so that we don't build in little technical mistakes like this last sentence. So I'm 5 minutes over time. Let me conclude by saying there is a tool, and it's called purpose limitation. It has a long history, and it is competition kryptonite. It is lying unused in the GDPR. Second, Ireland is the GDPR bottleneck. I have not heard any credible suggestion that that is not the case. Third, to fix that problem, we need to see the European Commission do its job as guarantor of the treaties and see that European law is enforced. And finally, as an aside, we need to make sure that the DMA does not harm the existing tools we have in the GDPR. Ladies and gentlemen, thank you very much.
Many thanks, dear Johnny. I would like to invite you to the floor. Please join us.
Microphone switch back on properly.
Couldn't see Anne-Catherine, but she is with us as well. And Marco Alexander is coming. Maybe the lady in the middle?
Yep.
Hi. Ich habe dich nicht gesehen. Bitte.
Hi.
Bisschen, ja, bitte. Needless to say, I think everybody knows her in Germany, Anne-Catherine. She was also candidate for the German parliament, unfortunately not among those MPs who is going to fight for digital rights and better regulatory environment, but I'm quite sure that from different positions that she is going to take her part as well. Welcome, Anne-Catherine. And also someone that is regularly joining us for the European Data Summit. He was last year with us in charge of AI, and also Mr. Gaia X. I think I can call him like that. And I think if we think of industrial policy in Germany and all the cloud stories, I think Marco Alexandre is quite known. We would like to talk about European sovereignty. I mean, we have the DMA, we have the DGA, DSA, and almost every talk is connected to data and digital sovereignty. You could listen to Johnny's remarks, thesis, critics. Basically, he is telling us enforcement matters, and he basically in charge the DigiJustice to do his job, and hopefully this will change in the near future. What are your thoughts listening to him? Who would like to start?
Okay, thank you. First of all, thanks for having me, and good evening to all of you at home too. I think the most important part, and I am as a representative of the German Ministry of Economic Affairs, I think it's not my place to criticize either the Commission publicly nor certain member states. But I would be very, very grateful if we weren't talking about regulating American companies, but more about regulating European companies. What does that mean? The problem that I see is that all these megacorps and all these GAFAM, they come from territory outside of the European Union, and the European Union businesses, they are way too small to compete with them. And what I mean is not, I don't want to regulate the European small and medium businesses or the European digital giants that are in the making. I want European companies to be as competitive as they can, and I want them to be as big as they can, and I want them to be the pacemakers of data sovereignty and of data relations in the next years. And to get there, we need this regulation. Because this regulation is what, and in the end, emphasizes the worth of a level playing field. And if we can have a level playing field, and you have perfectly shown how enforcement is part of that, not only regulation, then we get into a situation where products and services from European companies are way more important for customers and way more important for citizens and are at the heart of the legislation. And I think that we are always fighting a war between the narratives. The first narrative is, look, we need to regulate first, and then by regulation we establish trust. And when we have established trust, people will buy European products. And we, in that never-ending hassle, we say, look, it's the other way around. We need products first from Europe, and then when people buy European products because they are competitive, then we can enforce European values, European regulations via these companies, and bring the results of the European superpower of regulation to all companies and people on the globe. And in the end, I think the truth is in the middle. We need to emphasize the opportunities, especially of small and medium enterprises, to be competitive. And as I said, you showed perfectly well that enforcement is part of it and not only regulation. But the thing is, by only regulating right now, we are always in a race, but we try to get the attention of global policymakers, and we try to keep up with GAFAM, but in the end, the GDPR has shown that if we regulate things, for example, California, they adopt regulation, but they don't take 400 pages, they take only 20. They take the best parts, and we lost the race for regulation again. So my point is, in the end, we need to make sure that the companies that we want to regulate come from Europe and not only from other territories. So in the end, we can foster our European values and foster European regulation through good business models and through good products that people actually want to buy and want to be using.
Thank you. And Katrin, what are your thoughts?
I think you're very much right in saying the truth is in the middle. I think you both have very, very good and important points on this. And maybe to be a bit optimistic, I think it's super important that we as society, as European societies, finally have these talks and talking about what does sovereignty means for us, what do we want, what do we need. And all of this is still pretty new, you know, this whole digital sphere, having so much data, being able to process so much data. And so I wouldn't be that pessimistic in saying we're way behind, so we are still learning. And I think when it comes to regulation and these talks we need to have as societies, what do we want? How can we put this into regulation? Now I lost what I wanted to say.
But maybe to add, maybe to thinking of the last crisis, everybody has noticed that the market capitalization of GAFAM has grown. Well, we are talking all these years about data and digital sovereignty. So I'm wondering, are we on the right way, on the right direction, and how long will it take?
Yeah, that's, I think, there where I lost what I wanted to say. I think we need to become way more flexible in our regulation. So when I look at the GDPR, for example, it took too long, way too long, to discuss what we want. And now we see it's not fitting anymore to the environment we're having currently. And as you said, it's few pages too long when we look at California, and we need to adapt, I think, quicker to current movements, to developments in society. And I think it's regarding all processes we have in politics. We need to become more flexible and adapt to current changes.
Johnny, are you optimistic that we are on the right way?
It's hard to be optimistic. I am becoming tired because this has been going on a long time and it's not moving in the right direction. Let me say a word or two about the idea of companies and this, you know, this idea that the industry might produce a solution. I remember testifying on behalf of my last employer at the US Senate and telling them, we here in America look at the GDPR as an enabler of innovation. And if we had a USA GDPR, which is based ultimately actually on American principles from the 70s, upstarts like us could compete with the people who have taken all and are now causing trouble in the market. So the law as an enabler, I would be hesitant to dismiss it, and we didn't when I was in industry. The second thing about the California, there are two pieces of law you're probably thinking about. I was a little bit involved in that. You know, the first one is ineffectual, and that's why they have another one. And it's reasonably long, actually, and it's pretty closely based on some of the GDPR, and I think there are reasons why they weren't able to get in more. There was a negotiation process. But this idea that the GDPR is somehow outmoded, if it's outmoded now, it's not because it was introduced in, you know, in the last few years. The principles are based on the principles from 1995, and they are completely technologically neutral. So I haven't seen a part of the GDPR that I could really credibly imagine is outmoded or that the document is too long. It's pretty easy to read, and for anyone who doesn't want to read the whole thing, it's all summarized in Article 5, which is half a page. Any business that reads Article 5, the principles, and does those things is pretty close to where they need to be. I know there's detail, but you know, this is not rocket science.
Maybe if I can re-emphasize my point, it's not about the length of the actual document. It's about the complexity of the document, and it's about the complexity of the regulation and the imposed effects on small and medium businesses if they want to achieve something with the data. Bitkom lately presented a survey where they said, look, we have been talking to people and companies, and they said 90% of them said they have been actually dissolving projects because they were afraid of coming in conflict with the GDPR. I don't know about the big American companies, but they seem to reign supreme still. So I don't see them to take the same amount of cautiousness towards GDPR than small and medium businesses, because they are affected by it. And if they are sued, they are in a very bad position. And big companies can afford to be sued. And actually, they can afford to be sued because they are not actually, the rules are not enforced. So what my point was is, if we already have the point of view of regulation is solving the problem, then we forget about the business and the solution and the services side. And what I try to achieve with my work, and other people in other countries try to achieve with their work, is that we get into a situation where European companies are as strong as the companies that are not from Europe, and so we can compete and then export our values and actually the GDPR by companies that actually adhere to them.
Let me agree with you on one essential thing, which I think is implicit in what you're saying. The failure to enforce the law that we have, the GDPR, has definitely advantaged the big players, unquestionably, and it has disadvantaged, local football teams. GDPR is being thrown around by people who don't know and who it doesn't really matter too much with as a thing. And yet it's being theatrically ignored in an exquisite theater with lots of consultants and legal fees by the big players, but they're not delivering on the substance. It comes down to the enforcement question.
We haven't agreed the questions, but I would like to use this opportunity that I have Anne-Catherine and to put this discussion in actual context. Do you believe that maybe the new government, in the context of the new data strategy or whatsoever, can do something in this respect in order to have better enforcement, to have the feeling that we have back control to our data? What's your feeling or opinion on this?
I really hope they will do that. So when it comes to enforcement, I think we have a problem here in Germany that we have 17 data authorities.
16 plus 1.
Yeah, 16 plus 1. And they often have different opinions. And I think this is a big problem. And I think in the coalition treaty, they said they want to institutionalize the data commissioners conference. And I think we need to find a way to make a consistent, coherent ruling so that companies have the security that when the data commissioner of North Rhine-Westphalia, for example, says something, that it's valid in whole Germany. And so, as you said, we have a lot of companies here in Germany who are simply afraid of the GDPR, and that's a very, very big problem, and they don't want to do something. And yes, maybe it's some short paragraphs, but what I hear from a lot of lawyers, and I'm a big fan of the GDPR in general and data protection, is that it's way too complicated. And you mentioned Bitkom, and Bitkom, I think they made a survey in the beginning of the GDPR where they asked companies if they adapted the GDPR completely. And I think there's no company here in Germany who says, even the small and medium companies, that they completely adapted to a law. And so there are some problems with the GDPR. And my party, the Free Democratic Party, they want to have new discussions on this. I'm sometimes a bit afraid that they want to lighten data protection. So I hope they will improve enforcement and that companies can adapt to it. And I also really hope that the new government will talk more about how we can use data. So talk more about data politics, policies, and not only about protection. And as I said, I think data protection is very important, but we need to talk more and broader about how we can use data as a society in general, not only as businesses, for example.
You would like to add, please?
Yes, being a government representative right now, I am not really yet aware of the position I am about to represent because the government is still in the making. But I see there is that I have the feeling that there is a very seldom opportunity here, and this is each and every one of us is a citizen, and we are a customer. And the thing is that the citizens want to protect this data, and the customer wants to buy a convenient product. And sometimes these things come. There's citizens that do not want to share their data with, for example, their insurance companies. But on the other hand, they buy products of that track their life, life science, their life science, and track their pulse and all these things. Data which they never would share with their insurance companies, but they share it with American companies. And as long as people have these two hearts beating within themselves, and we do not really get these together, bring these together, and make them make this a coherent approach, like you, Ann-Kathrin, said, then we still have a very narrow approach towards legislation and a very narrow approach towards really convenient products.
Thank you. We can have also a question from the audience, so please get ready. In the meantime, I would like maybe to make a small remark when it comes to the enforcement issue. We can't complain that much that enforcement doesn't work, because when we think of all the competition cases and all the fines in the last years, obviously it doesn't hurt. So what if we have even enormous fines by data protection authorities that won't change the picture that much? I'm again trying to come back to the original position, how to achieve our European approach and sovereignty in
fines are not it. If you can have a dissuasive fine, great, but clearly the fines are not dissuasive. The enforcers have the power to level these fines, and that's all very well, but much more important is that they have the power to go into any organization, having conducted an investigation and done so lawfully. They can go into any organization and compel or get a court to compel that organization to stop doing what it's doing with the data. There is no company, no matter how big it is, that would not be subject to that. That's the thing the companies fear, and that's all that matters.
Okay, do we have maybe questions from the audience? Yes, please. First, let's start there, then Professor Kerber. Please introduce yourself. Or Professor Kerber first. Okay.
Ryan, I like very much your point, but I'm asking myself whether you are too optimistic in regards to GDPR. Because you said it's the problem with the Irish Data Protection Authority. And I'm not sure whether the enforcement would be much better if the Irish Data Protection Authority would work well and would work as well as all other data protection authorities in Europe.
Oh, so I didn't say that.
No, is it not the problem that the entire enforcement system of the GDPR has really defects? Do we not need a European data protection authority which is as powerful as the European Commission in competition policy, and therefore a centralized agency for really dealing with the big digital platforms?
I have an answer, and then I'm going to give the second answer. The second answer is I don't know, but let me give the first preamble to that. First, I'm not suggesting that the Irish are massively worse than the rest. It's just that Ireland matters so much. I don't want to embarrass any enforcers, but there aren't too many shining examples. I actually can't think of a shining example that I can give you right now. So as individual authorities, there are problems to go around, but Ireland is the one that matters right now the most. Second, this idea about taking that problem of an enforcer that isn't doing its job and moving it somewhere, it reminds me of Ireland and the problem of the Catholic Church, when in a parish it might turn out that there's a priest who parents are complaining that the priest is molesting children, and it turns out that the church's solution is to move that priest to a different parish. They don't deal with the problem. Whether the enforcer is in Brussels or in Dublin may not matter too much. And let me give you some examples. If the Commission, and you're talking about DG Comp, if that's your example of success, you have a different view of the market than I have. Maybe you're thinking of ENISA in cybersecurity. There aren't many brilliant examples, correct me if I am wrong, of this working when you move it to Brussels either. So one way or another, we need to get an enforcer that can do its job wherever the hell it is. We need to deal with that problem. But we can deal with it very neatly now by fixing the Irish one now. And in our recommendations to the government, and this has also been backed up by a cross-party recommendation from the Irish Parliament and Senate Justice Committee. It's 18 different recommendations, but one of them is an urgent review, independent review, to reform and strengthen that organization and figure out what's going wrong. And second, reform the leadership by appointing 2 additional commissioners at the top. That would help move things, I think. And maybe other things are necessary too.
We had one more question, please.
Thank you, Wolfgang Dierker. I work for Apple, and I'm very grateful for you to setting up this event. This feels like the second last chance to meet people in person, so really grateful for you to set this up. So I work for a company that does not sell data, but sells devices, and the most of the revenue we make is from selling devices. Sometimes it feels a little bit like comparing apples and pears, no pun intended, when you put the company into the GAFA category. But that aside, I wanted to build on Marco Alexander Breit's statement on regulating European companies, as you put it, meaning creating regulatory conditions for European companies to grow, to innovate, to provide values, and also in line with European values. So thinking of the Apple App Store, obviously, we continue to provide a platform that helps European and German developers to grow. We have thousands of developers, hundreds of thousands of jobs that are built upon this platform, and there will be unintended consequences, we fear, from the DMA. But the question I wanted to ask is, somewhere in between the discussion of the GDPR and the DMA, I may have got lost, but what are your concrete suggestions to do in order to get European companies to grow? So what are the regulatory conditions that need to be changed in order for European companies to grow, innovate, and create values? I may have missed, but I would be really curious to hear a little bit more detail on how exactly what we have to do that, because I think it's totally right.
I think the question is directed to me, right? So yes, thank you first and foremost. We could talk a lot about Apple and its business practices, and especially the App Store and how it impedes or benefits companies that want to bring their applications to the market. But taking that, there's 3 things I think are very important. The first one is taking into account small and medium enterprises, and we have seen it with the AI Act that's coming out, that what has been getting out yesterday evening, that small and medium enterprises are being taken into account, especially taken into account. That's, from our point of view, one of the most important things. The second thing is that we need to make sure that European companies too have the access to data, which means that as long as especially cloud services are provided by only big corporations, so-called hyperscalers, then the data rivers, they only flow towards the big ones. What we need to make sure is that the small ones can even access that data, that small companies from Europe have a level playing field when it comes to cloud storage and edge solutions, which means in the end that we need to make sure that lock-in effects are no longer working. This and the access to data to make data on a voluntary basis more achievable and more have a broader access is the goal of Gaia X, for example. That's the second thing we are doing. The third thing we are doing is that we try to make sure that, and especially in Germany, colleagues of mine are tomorrow here to explain the German competition laws, and that we want to make sure that the level playing field is especially, there is a very strict approach within Germany, especially towards bigger companies and abusing their market power. So in the end, there is a lot of leverage that we have and a lot of measures that we can take, but they need to be coordinated. And then, as I said, it's just not doing this and doing that. It's taking into account that people make business decisions, people buy things. And if I don't take the people serious because I reduce them to citizens and forget that they are customers, then I make it wrong. And if I reduce them to customers and forget that they are citizens, I make it wrong too. I do it wrong too. And in the end, we need to combine these few perspectives, and then the regulation will be a good one.
Having in mind the time restrictions that we have as well, I will start the sentence, and Ann-Katrin, please bring it to end. In order to be sovereign, we have to do what?
I hate this game so much. So in order to be sovereign, we have to do.
Yes, in order, I mean, you have inspiration also from the representative of Apple, because this is really a legitimate question. We are doing a lot when it comes to DMA and GDPR, but what actually we have to do finally in order to have to see European companies grow and to achieve more when it comes to sovereignty?
I always think about that I have to reply to your email still. No, what we have to do, I think, in order to support European companies, that was what Marco said, we as state, as a government, need to support these companies, for example, in being their biggest customer. We saw it with BioNTech, for example, here in Germany, and we can do this in the same way with tech companies, for example. We saw it that the German Bundeswehr, the armed forces, they bought a messenger service, an open source one, from a European company, and they're using it now as an internal messenger service. And I think these are, like, we need to identify what do we want. As I said, where do we want to be sovereign, and then support European companies who are producing products based on our values, such as open source software products, and then be their biggest customer and support them.
Hashtag European champions. Industry strategy. Okay.
I just want to, I want to second the part on open source. It's way more important than we think.
Okay, Johnny, please finish my sentence. In order to be sovereign, you told us a lot. Maybe your final remarks.
Something like 15 years ago, I wrote a book on the history of the internet, and I was about to say, fight a big war, because that's where a lot of the tech sector ultimately has its roots in all sorts of surprising ways. But another way to put that is big projects like Gaia-X. And it's the power of the public sector purse, of public procurement, but also to set up things like Fraunhofer Institute and so on, to run big things that innovations can roll out of. I think that is potentially, looking at the US example, that's certainly where their dynamo came from. It came from the state, amazingly.
Thank you very much. I really enjoyed the discussion with you.
Thank you.
And we continue with the so-called Google hearing, hoping that Louis Crofts is with us, at least virtually. Is he with us? Not yet. Let's wait a couple of minutes. Many thanks to you.
Thank you.
Thank you.
Thank you.
Good to meet you.
He's not there? He's there. Perfect.
Do we clear up?
You can go. The travel ban was faster than Louis' plane, so hopefully he's with us virtually. Louis, yeah. Perfect. For those that doesn't know Louis leads Emilec's editorial strategy, content direction and development. He has a reputation for breaking stories and providing analysis on complex legal disputes before regulators and courts around the globe. A graduate of Oxford University. Are you listening to us? I hope. Again, a graduate of Oxford University, Louis worked in academia and at Charles University in Prague prior to becoming a journalist. Thanks to Louis, we've learned what's going on in the courtroom in cases against Google, Amazon, Apple. Statements like, all roads lead to Rome, not Rome, or if your search engine is so good, why did you use pre-installation contracts to force it on user phones? The objection by the European Commission. We've learned of those sentences thanks to Louis, thanks to his live reporting from the courtroom. Dear Louis, are you listening to us? Does it work? We have tons of problems. You're unmute, hopefully. There's no audio signal, or? We can see you, but that's too little because we need your clear words. We're not.
Sorry, I can hear you. Can you hear me?
Perfect. Perfect.
Ah, brilliant. Look at
Perfect.
that. That's what we need.
We
a big
didn't want to
text.
miss you, Luis. I said that the travel ban was faster than your plane, and we are really sorry for that. But we are really happy that you can join us virtually. Could you tell us a bit more about the mood in the courtroom? How would you describe the general mood in the courtroom at all these cases? How convincing is the commission? How convincing are the gatekeepers?
That's a good question. And thanks again for inviting a journalist to your esteemed event for the second year running. I apologize for not being able to make it. I've covered a lot of these cases, sitting at the back of the room and looking at the backs of lawyers' heads as they argue their way around tricky legal things. And you do get a bit of an insight into how companies behave or how they want to be perceived. And while a lot of the debate, like the debate we've just heard, a lot of it is about regulation. The words of the judges do have the final word, as we've seen from the Google shopping judgment, a week or two ago. They really are powerful messages from the courts. The biggest problem with the hearings is they take ages. It takes ages for the case to come out. That's part of the issue which new regulation is trying to solve. I mean, when I went to the Intel hearing, Intel was the biggest find at the time. I went to the hearing and it was a 5-day hearing. I left after day 4 to get married. And I went back to another hearing in Intel, and I've now got 2 children. One's 8 and one's 6. This is not a statement about my reproductive efforts. It's more a statement of the slowness of the court. It's still going with this case nearly 20 years on. So, don't expect answers quickly. But to come to your question about, what's it like in the courtroom? Well, essentially, the court hearings on these cases are part theatre and part law school. So the theatre is always the beginning. There's always these big opening statements, which are made in this easy language. They're meant for people like me, for the press, who are at the back of the room, and they tell the stories of the big benefits of the internet, of search, of the power of the iPhone, how we can buy anything we want online. Those are meant for my ears. They're also meant for the ears of judges who haven't done any reading on the case, and there usually are some judges who haven't done that. During this phase, you get a lot of good lines. I remember the commission saying about Microsoft had been fined for not obeying the law. And the commission said Microsoft was like a gambler who doubled down and lost. And in the Google hearing, the commission said, Google is a colossus and its algorithms consigned rival services to the darkness that lies beyond page 2, like some sort of apocalypse. These are all things which the press, write down furiously. They make for good copy. But when it comes to the companies, the Googles, the Microsofts, and so forth, generally, they try to seem very reasonable and very approachable. The public debate about what they do is a massive storm. It's a total tempest about, everything that they do with data and their intrusion into our lives and so forth. But when they appear in court, they tend to go quiet and they go reasonable and they pick 1 or 2 arguments. One example is when Apple was in court about its tax bill. You might remember the case about arrangements in Ireland worth 13 billion in tax breaks. And it was Ireland which had the lawyers that were going red in the face, banging the table, saying this is outrageous, that the European Commission will intrude in the sovereignty and the fiscal policy of Ireland. And then it was Apple's lawyer who stood up and said quietly, but we're just doing what we can do according to the law. And please, understand, we're just a company like any other doing its business. So that's the way that these things pan out. In the past, you get older industrial companies, French cases, German cases, where you get the lawyers who start off with, this is an outrageous case, and what would the founding fathers of the union think if they could see this case before them? There was a lot of that 10 years ago. There isn't anymore. People go quietly when they're the companies. On the other side of the room, the commission also generally goes quietly. It also avoids any of the big philosophical battles about the future of the internet and Quo Vadis, antitrust law, all they have to prove, all they have to answer is the question, is there anything wrong in my decision? To which the answer is always no. So it's imbalanced in the room. You get then the complainants. These are often companies who've suffered a lot at the hands of big tech. They've gone out of business. They've got litigation in national courts, and they come in very, very forcefully. They feel very passionate. This is their day in court. This is their day to finally tell the judges how they got exploited by the large tech companies. So that's for the theatre. Then quickly it descends into law school. After those opening statements, most of the press either leave or start doing Sudoku on their laptops, and then the debate goes into abstract concepts which are very difficult to write about. Then the press wake up again a little bit later at the end when there's a debate about the fine. There's always big fines. The company always says the fine is too high, and the commission says, well, it could have been higher. Count yourself lucky. So that's how these things go. The judgment's the same. When the judgment comes, like it did a couple of weeks ago, there's the theatre part of it, which is who's the winner, who's the loser, and then there's the law school part of it, which is the very, very difficult assessment of the essential facilities criteria or whatever. But that sort of fight to be the winner is always a big play. You get these cases, particularly ones that come out of the WTO, where it's Europe against America, the WTO rules, and you get two press releases. America welcomes the judgment. Europe welcomes the judgment. If both people welcome the judgment, there's something got to be wrong. So that happens as well. But so it's a lot of it is theatre, and then a lot of it is law school. And that was the same for the Google case. The theatre part was about the future of the internet and whether Amazon was a place which was just as easy to shop on, and the law school part was all about abstract theories on essential facilities. So you get both these elements.
Yeah. The current drive of regulations and intervention in big tech has been driven by the investigations of Google by the European Commission that started 10 years ago. What's the role of media and how important are journalist briefings for what we have today? Finally, DMA on the table and much more pressure on enforcers.
I think journalistically, it's been a really interesting journey. About 10 years ago, there was, or even longer, 20 years ago with Microsoft, there was only ever really one tech story at a time. It was Microsoft, and then it was Intel, and then it was Google. And we would all hunt in a pack, and you're just trying to get anything on this one investigation into the shopping case. And you would follow the then commissioner Joaquin Almunia around, and every time he, stepped out of the toilet, you would run at him with your dictaphone, going Google, 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 hoping he would say something. It's just a lot more difficult now. Why? Because there are investigations everywhere. It's almost ridiculous. Every day, every week, there's a new probe of some sort. Ridiculous in terms of how we can cover it. There's new investigations on national law, on amended national laws, on EU law in the US, there's litigation and so forth. And it's very difficult to track all of those and give them all the scrutiny they deserve, because they're all, difficult or novel or important in different ways. So I think it's just a challenge. In the past, the Google shopping case was the lens through which everyone looked at future tech regulation. The lens now is, it's like an insect's eye. There's 20, 30, 40, 50 sort of views going on at the same time. I think the tech cases as well are a double-edged sword for regulators. They're a very good way for regulators to show their relevance. People know about the iPhone in their pocket or the Amazon, thing that they bought for Christmas. It's a very good way for regulators to get close to their citizens. At the same time, if they don't deliver for those citizens, and these cases can be and are difficult cases that require clever people, resources, and sometimes novel theories. And if you don't deliver with that case, and at the end of it, you haven't been seen to repair the internet or make your phone cheaper or allow greater choice, then the pain that you receive and the criticism that you receive afterwards is all the greater. So I think it's a double-edged sword. Finally, as you said on the DMA will change things for reporters. To date, basically, it's been about running after a handful of antitrust cases, which in their essence are very secretive. And they always have, on the one hand, a bunch of people who are complaining and often vocal, and then a tech company which is trying to be quiet and create a space where it can talk to, regulators about remedies or whatever. And the DMA changes this because you don't get long-running secret probes anymore. You'll have shorter timelines. The complainants will have a different role. What kind of stories will we write? The story will be, Apple designated as a platform of, cross-border importance. The sort of designation story, and then another story later about what the remedies are, and so forth. It's a different thing, not the kind of Google faces $1 billion fine over, which is the standard story which a journalist writes. So you'll get lots of, as ever with new legislation, lots of procedural nerdy stories about someone appealing this particular article, and we'll have to sort of get those out the way first, I think. So it's going to be a challenge for reporters, and taking this kind of creating a brand new framework to follow. But we've done that, and people do that. We've done that for telecoms. We've done it for energy. It exists in the press as well as it does in regulation. Okay.
So you're quite optimistic when it comes to DMA. What's your forecast? DMA enters into force, like let's say in 6 months. When is your first live reporting from the courtroom regarding Article 5 and the so-called self-executing norms?
No, I think there'll be there'll be stories on the actual cases which it produces, but I think there'll also be someone will, through some vehicle or other, dispute the entire law and its legal basis. I think that's that will happen. It happened with the roaming regulation. It was the UK telecoms providers who went to the ECJ, sort of manufactured, created, navigated a route to the ECJ to say this has been adopted under the wrong legal basis. And I think people will do that, essentially arguing this is a piece of competition law which is expropriating us, and the way it was adopted and the way it's had its legal underpinnings doesn't correspond to that. I think we'll see that case will probably come much later, but I reckon it depends a bit on the regulators how quickly they choose to designate and stick to the timelines which seem to concertina in the amendments. But my point of comparison will be the German law, where the Bundeskartellamt has opened cases under 19a GWB into all the big tech companies to sort of designate them, and we still haven't had any news on that. So and that's a big grown-up regulator looking at big grown-up companies. It will take time.
Thank you very much. Please continue reporting from the courtroom in unconventional language. It really makes a lot of fun. Now we have a small break, and Luis is going to join the discussion later again with us. Many thanks.
Thanks very much.
So now we have small break, 15 minutes, and then we have the DMA part with Christina, Tommaso, and Austin. Thank you. Here we go. Many thanks. Ladies and gentlemen, dear guests, we are back in the Academy of the Konrad-Adenauer Foundation. It is my greatest pleasure to invite Tommaso Valletti, professor of economics at Imperial College Business School and also professor of economics at the University of Rome. He is non-executive director to the Board of Financial Conduct Authority, and he was the chief competition economist of the European Commission between 2016 and 2019, basically involved in many, many important cases in the past. Besides economics, he is a keen flute player, and he is excellent writer. I'm recommending to you all his articles, papers like Doubt is Their Product, the difference between research and academic lobbying, or why big tech companies should engage with academia and why they don't. My greatest pleasure, dear Tommaso, the floor is yours. Please.
Thank you very much. Thank you very much for the Konrad-Adenauer-Stiftung for the invitation. So, good evening, everybody. First, a disclaimer, I'm an academic and I'm not engaged in consulting work. When you have academics, I think it's always important for the sake of transparency to just to state whether you're involved in any of these businesses or not. I'm not. So I've got my brief keynote of 15 minutes and then we have a round table, a panel where we talk about the DMA. But in my 15 minutes, I thought I would make 4 points. And I'll try to be simple, hopefully. So first of all, I want to talk obviously about digital platforms, and this is opinions which I formed over the past 20-something years of career as an academic, but also as a person very much keen on policy. So what happened in the past 20-something years? So the digital internet started in the early 90s, almost 3 decades, and to oversimplify, but I would see 2 phases in the development of digital platforms. The first phase that was open, dynamic, it was anarchic perhaps, coming obviously mostly from Silicon Valley, and those were the years where many of the brand names we are familiar with today emerged. And maybe just a coincidence, but I also want to say that those companies started when the very last antitrust case was run in the United States. So at the time, there was Microsoft, that was the digital giant back then, that was trying basically to enter all sorts of new businesses that were emerging. At the time, they were called browsers, they were called media players, but it was an antitrust case, the last one under the Clinton administration, so imagine how long ago it was, and maybe by coincidence, that gave oxygen to a new generation of entrepreneurs and startups. That phase was also a phase where there was a good deal of academic involvement. As I'm an academic, so I'm interested to see what my peers are doing. Let's not forget, for instance, the Brin and Page, so the founders of Google themselves, they were finishing their own PhD in computer Stanford in 1999, in computer science, Stanford. Okay, so that was the origins. And then we kind of lost track, and we didn't understand that then things changed pretty soon, despite, in theory, economists could tell you there are economies of scale, network effects. And we have then the second half of these 2 decades, 3 decades almost of digital platforms where we have incredible consolidation, where we have dominance emerging, abuse emerging. We depend, so we must have witnessed all ourselves how our lives are totally dependent on, for good and bad reasons, on a handful of American companies. So during the pandemic, you must have seen it yourself. So this is a bit less known to the general public. Obviously, here in the audience, there are people which are experts in the fields. But Google has been, for instance, dominant in search. And by dominant, I mean in excess of 95% of global searchers, excluding China, for the past 14, 15 years. So this is not the idea that these markets are subject to rapid dynamics. I mean, this is long, okay? And you can find similar, and if you look at searches not on desktop but on mobile phones, it's even more. And because on mobile phones, there are only 2 operating systems. One is owned by Google, that's Android. And when I was at the European Commission, we ran cases because Google was abusing its dominance there because they saw that there was the mobile market emerging. But Google is also paying in the range of $15 billion a year to Apple to be pre-installed as search engine on Apple II. So if you're a rival search engine, you don't have access to Android because it's Google, but you don't have access also to the iPhone because also Google pays to be there. Okay, so similar numbers, maybe not as large, but would be in social networks for people age 30 and above. There are statistics you can get from Amazon. Last year, 80% of the people in Germany and 70% of the people in France, or the other way around, I don't remember, bought on Amazon during the day, during the year, during the pandemic. So this is where we are depending. So this is the opposite of what we call resilience. Resilience is when you have alternatives. If you depend on very few, this is not a very resilient system. So as I said, this is a bit less known that this has been going on for long. So in a sense, it's very welcome, all the policy developments that we have. It's a bit too late. Well, it's definitely too late. But the narrative often is still, it's all good. You hear that, competition is one click away, where the dynamics is going to fix the problem. What's the problem anyway? So we are always chasing a little bit what's happening in this market. So it's good that we realize, and there are finally legislation coming, that we're long overdue. First point, therefore, these 2 phases of digital platforms. Second, what's different when it comes to big tech? So we had disruptive innovation in the past. We cannot say that, the steam engine wasn't important, or electricity, or railways. But what's different when it comes to big tech? I think there are a couple of features which are really new. One, which is well known, is the speed and the reach of these platforms. This is unprecedented. So the ability to connect 3 billion users on the Facebook network is new. So you didn't have that in the past. So speed and reach, but also something more subtle, which is almost paradoxical. And the paradox there is that these platforms have eliminated barriers, especially in geography. So, I can talk to somebody in a different continent. I can find a product on a different continent. So it has eliminated especially geographic barriers. That's good. And this is also railways, perhaps, has eliminated barriers. But then it has also recreated barriers in ways which are much difficult to understand. So for instance, if I open my social networks now, I would be targeted with advertising which depends on my own profile. Okay? And if instead Johnny or Christina or Pencha are opening their own social networks, they will have different messages, different news. They will be reading different things, will be exposed, and have no possibility to know what they are seeing because I'm not them. I don't have their own profiles. Okay? This is really of the silo system. So this is much more intangible. So where we become individually as relevant markets in a competition law jargon, which makes it very difficult for regulators to deal with these companies, okay? Because it doesn't belong to any box. Just to give you perhaps examples, which are just by analogy. In the old world, I could see if segregation exists in cities just by walking in a city, okay? And I could see whether downtown there were only black people, deprived or not, but everybody could have access to that. Now this possibility is not available. So I don't know if there is segregation. There is probably segregation, but I don't have the possibility to become a different persona from what I am, because my digital profile, my history, my different connection have identified me as a person which is different from another person. So this is much more intangible, but these barriers exist, okay? These barriers exist, and this is completely new and explains to a large extent why it's been so difficult to put these companies into boxes belonging to the old world. So this paradox of barriers being eliminated, but also barriers being rebuilt in ways which are very difficult to find. The third point is again another paradox. It's about data. This is 3 days about data. The paradox about data is that an unprecedented trove of data about us has been collected over the past 20-something years by the digital giants that we are all familiar with. None of this data has ever been made available to academic, independent researchers to see what's going on. Zero. So I'm not exaggerating. Zero. Okay? Zero, especially to the economists. They are just so the paradox there is so much data, but we cannot use as academics. And why is that important? It has huge implications. It has huge implications, not just in a parochial way as an academic, but more also as a system of checks and balances that we need in a democracy. So academics, and I speak for my field, I don't want to overgeneralize, of course, but academics, if they don't have data in economics now, they cannot publish. Because we have to publish empirical work. And if we cannot publish, we perish, as people say, publish or perish. So if you know you're not going to find data, you walk away from a field, you're going to go somewhere else. You're going to be looking at, I don't know, maybe developing countries, you're going to run experiments there, you're going to do, maybe there is data coming from central banks, so you study monetary economics. When it comes to digital platforms, since no data was ever being made available to academics for publication purposes, you have generations of academics that did something else. They walked out because otherwise they would have been dead. And so this has really slowed down in a dramatic way our understanding about the field. So a paradox there for me is that now in 2021, if I speak to the average economist, they would tell something about digital platform, which is something we already knew 20 years ago. They would say, oh, digital platforms, oh, but they're efficient because of network externalities. However, network externalities also bring the risk of monopolization. There is a trade-off. Thank you so much. Okay? I think, is that very deep? Is that so deep? This is something that we could have said 20 years ago, if not even earlier. Okay? And our understanding has stopped. And this is important. Again, it is important because in the conversations we have, we lost a generation of talent that have not looked into this. There are solutions there. For instance, I'm very hopeful I'm not an expert of the Digital Services Act, the DSA, but there is a provision there, which is Article 32, which I understand that finally some data will have to be given to scientists, but we need to gear up to be ready also for that, which I don't see really happening yet. So this was the third point, the paradox of data, which are so much available, but in this respect, I have no hope that there is going to be any change from the digital giants themselves. Why? I personally, when I finished my job at the Commission, since I had so many ideas of interesting research questions, important research questions, I approached some of what I thought would be the more open-minded among the big tech. For some big tech, I just gave up, but some I thought they were more open-minded. We tried to have a discussion about giving data to researchers, to have a research center, and the conversation didn't go anywhere because at some stage they only saw the downside, the downside of, they would basically ask him, but what do you want to prove? Okay, what are you going to find? I said, but how can I know what I'm going to find? It's not a good research question if I already know the answer. And so, and they didn't see any interest in that. And so, and as soon as you have the lawyers brought into the room, they will say, no way. And they started attaching strings which are unacceptable for the integrity of research. So I just gave up. I said, no, thanks. But still, we need some regulatory intervention. Otherwise, there is an impasse that will never be solved. The last and final point that I want to make is about the fact that as chief economist of DG Comp, I ran some cases, so I had the opportunity to see some of the data that obviously I couldn't use because there is a confidentiality. But by looking at the data, I updated also my beliefs as an economist. In particular, I saw looking at the data in the Google Shopping or Google Android, there is a lot of inertia in consumer behavior. And there is not such a thing as a representative consumer. There's a lot of heterogeneity too. But it was interesting. So I saw that some of the basic tenets of perhaps an oversimplified economics that would assume lots of rationality was not in the data, whatever. So we are a constant, massive A/B test is being run on us by showing us something on the top of the screen, on the bottom of the screen, make it larger, make it smaller, and see whether we actually click on ads. This is happening on a gigantic scale on every day, and there is lots of behavioral traits that the companies exploit in order to sell more ads. So, but what was interesting is that I saw all this, we know behavioral economics has been out there for a while, but it doesn't even really percolated into competition law. That's fine. But when I was talking about the findings with other colleagues coming from different fields, say a social psychologist I was talking to recently, I said, well, what we knew about these particular things that people only look top right, bottom left, or something like this for the past 20 years. We ran experiments. But when I spoke to my academic colleague coming from social psychology, there were interesting discussions there because I said, but how come two things? Why what you know has never been brought to the attention of the policymakers, okay? Aren't you interested in that? But policymakers, they were saying, which policymakers? Do you know there is an ongoing debate to regulate digital platforms? No, we are not aware in academia that there is this kind of ongoing discussion. So a total disconnect both ways, okay? So the social psychologists' research, important research, was not brought to the attention of people that would have found it relevant, and vice versa. The social psychologists didn't even have a clue that there is an important policy discussion out there. So the last point I want to make is that currently there is, and today obviously is an exception, but an exception that proves my general proposition, which is that there is an incredible lack of diversity of views when it comes to the discussion in competition policy and digital platforms. So I was in Brussels full-time for 3 years. I had to go to DC several times, and the discussion there were completely hijacked by lobbyists or policy people, or so the people that the big tech are sending to the discussion are not the computer scientists. They're not going to explain you how an algorithm works. They're not the engineers. They're not people that know how things are working. They send you policy people who are very well educated and eloquent just to tell a story that the company wants you to hear. And the narratives are still there. They are still leading the discussion when it comes to Brussels or Washington, D.C. So, for instance, we still hear small and medium enterprises, they love us, they need us because they need us for their businesses. I found it really interesting that Facebook and Google are buying ads in airports. And in traditional media, the opposite of the hyper-targeted advertising they do to say SMEs, they love us, they need us, etc., because they want to affect the policymakers, because the policymakers which are still going through airports and the policymakers which are still reading the Financial Times. Obviously, it's not the SMEs, but that's what they do because that's the narrative they want you to hear. And similarly also, the public affairs people will tell us, oh, killer acquisitions. which is so bad because that's the channel for exit of the entrepreneur. You're gonna, again, disincentivize them completely. Or privacy, we care about privacy, but privacy has nothing to do with competition. Privacy is about consumer protection. It's a different field, and you heard from Johnny before that obviously this is completely wrong. So having more diverse views, and this is perhaps one of the achievements of the last few years, I would think. So it would have been unprecedented to have a privacy expert, competition expert, and also this, the civil society being out there, but still there is a coordination problem because these are individuals, they don't have the same funding as the big tech corporations. But this is where I want to end before our panel on the DMA, that there is now, I would think, a very good train in motion now in Europe, which is great. Okay, lots of details will be incredibly important, of course, but the train in motion has finally left the station. That's exactly what we wanted, and we have to keep up this good energy, all of us. We also have to remain healthily skeptical, I think, of the main narratives that we'll still hear, because the money at stake is so large, and you have big departments which are meant only to just to contrast what I may say in a conference, but just multiplied by orders of magnitude. But this is what we need to do. So keep the diversity of the discussion, keep it open, and also, as somebody said in the previous session, we have by doing this, we also have to avoid making the mistake of solutionism. The mistake of solutionism is always be concerned about particular problems of that moment. Because if you just find a particular problem, a particular fix of a problem, and we've dealt with cases in the past, not particularly well through antitrust, but the risk is that the big picture is not in front of us. Okay? So we have to avoid this technological solutionism. Tell me what the problem is, and we'll give you a small fix. And we have, as somebody said earlier, is to sit down together, also imagine what we want for Europe. Okay? Because we are European citizens, and we want to have a very prosperous digital future for European citizens. Thank you very much.
Dear Tommaso, many thanks. Please join the discussion. Dear Thorsten, I hope you're with us somewhere here, please. Yep. And dear Cristina Cafara.
Cristina, want to be in the middle?
For sure. We would like to, please sit down, we would like to keep the diversity of discussion, as you said. And I think we have enough inspiration, not only after your keynote, but also after Johnny's keynote. What's coming first to your mind? Maybe let's start with Cristina. Cristina is, by the way, well-known in the competition world. She has, I believe, worked with many big companies that we have already named them tonight, and she's using quite strong languages. Most recently, I think also your voice counted in the debate when it comes to killer acquisitions, I believe. And Thorsten Geselberg, I think also in the competition world, is quite well known. I'm really happy that he is continuing to be our guest, special guest for the European Data Summit. We had exclusive insights in the new competition law last years, thanks to you, and I'm really glad that you're with us. Many thanks, Thorsten. But let's open the discussion. Cristina,
Thank you, Pencho. It's a pleasure to be here. Thank you and the Institute for the invitation. Let me start with disclosure very rapidly. I have worked multiple times adverse to Google, against Facebook. I've done work for Amazon, Apple, Netflix, News Corp, Uber, and others. So what comes to my mind? I mean, first of all, I'm delighted to be here with these particular two rabble-rousers, Tommaso and Johnny, two people who I really think are in many ways doing a lot to lead the debate and to point to what is absolutely apparent to my mind, which is we are in a market power crisis and we are in a data protection crisis. And these two are compounding each other. They're compounding each other because, of course, the market power which has been accumulated is what allows for data protection violations to be perpetuated consistently. And conversely, the violation of data protection in a systematic way is what allows for market power to continue to be accumulated and persist. And so the question is really, how do we deal with that? We heard Johnny eloquently, I think, lamenting the failure of enforcement on the data protection side and GDPR. I heard some optimistic words earlier about, well, at least in competition, something has been achieved. My message is a lot more pessimistic. I think that antitrust has been a pretty abject failure so far, generally. In that, although this is no aspersion on the people working on it and making a lot of good work and putting forward effort, the outcomes are not there. We've done a lot of work, there are some fines, but the fines don't matter. So what you look at is really, what has been the outturn? Have we moved the dial in antitrust in any way whatsoever? And my take is relatively negative when you look at the record, for a variety of reasons. Some are inherent in antitrust and make it very difficult for it to be effective in this environment. We have piecemeal enforcement which systematically misses the action. You're always enforcing against something which happened 7 years ago, and this is the case for shopping, it's the case for Android, it's the case for tech. In the Google case, it is the reality of antitrust. You're 7 years too late. The doors have been shut. The conduct has taken place, and the monopoly has been shifted from one environment to the next, and it is too late to do anything about it. Of course, the process is grotesquely gamed by defendant, delay. There is a certain reluctance on the part of regulators to really be quite assertive. There's a lot of concern about precedent. Can we fit it into this box, into this other box? There's a lack of courage in developing theories of harm that actually fit the current concerns. We have merger control that is incredibly weak. Now, kudos to the CMA yesterday blocking GIFI, but it is one in many that have not been touched. And fundamentally, there is this siloing between the data protection side and the antitrust side. This has been a campaign that with Johnny and Tommaso I've kind of pushed. One of the most demoralizing things is that there is a persistent distinction between these two fields, and a sense that each of them is actually protecting a little bit of its patch. I mean, I know the antitrust field much better, and it is dismal to me how the antitrust community is absolutely lagging behind understanding the role of data and how we can use data protection experts to understand market power and to deal with market power. This is something that doesn't really register. You are at a competition conference where antitrust people go. The perception, the narrative is that data protection is not our job. We deal with market power. This is something that, of course, also is persistent with the regulators, because that's who dwells. These are the kind of people who dwells with regulators. So I was at the Association of Competition Economists Conference in Barcelona last week, and it was incredible that when discussing the implication of data protection failures, the comeback from the economists in the room was, but what's not to like? More data means more better matching. We are going to get adverts that are better matched to us. This is good, isn't it? It's welfare enhancing. Or, but we know that health markets or insurance markets suffer from asymmetric information. So if we can cure the asymmetric information by giving the super dominant company the monopolies more data, well, we'll get a little bit better results. So this is the level of interest, understanding, and openness of the antitrust community. On the other side, you have the privacy people. This is not my tribe, but I also perceive there is a certain degree of sort of, who are you? You know, you're economists, what do you want to do? We are kind of people who do law, and we do data protection law, and we cannot really let you touch our data protection stuff because that's so precious that you cannot possibly understand it. So there is an issue of miscommunication, because one tribe talks about fundamental value, and another tribe talks about value in terms of money. And so those two don't yet speak well together, but that's a problem. I mean, if what Johnny was saying today was understood by antitrust agencies, we would be further forward. Because in merger control, we would understand processing and as an important unit of analysis. We would understand purpose limitation as one of the things that can help us do line of business restriction, and so on and so forth. The reality is that antitrust practitioners are generally totally ignorant about this, and they kind of think it's not their job. So briefly, just last comment, enters the DMA. If antitrust has failed, now we're pivoting towards this great new shiny, big, lovely object. And kudos to Andrea Schwab, who actually, and Stefano Corten and others who have actually rammed this thing through the parliament so quickly. It's a great achievement. We can talk a bit later. I am concerned that it will not achieve the nirvana that we would even begin to hope, because I think that it will be managed. It will be managed by the targets. It will be managed in a way that will, at the margin, lead to some improvement in dealing with the worst excesses of competition on the, abuses on the platform, but it will not create digital diversity, dispersion, any kind of distribution of power away from the key actors. Let me stop there.
Okay. Dear Torsten, is the state of play in the competition world that bad? Listening to Christina and she was. By the way, that we waited that long for our Competition Act was not because your readiness, but we had some political issues in Germany. But still, we are at the front of this movement. I think the Competition Act in Germany inspired the DMA a lot.
That's extremely kind, as usually. I would say it helped maybe nudging a bit the competition of competition people, because indeed for a number of years we actually heard when we, I just tried to recollect when the whole push for the DMA started, and I think the German government sent its first official letter to the European Commission asking the Commission to look into having an additional instrument beyond the antitrust rules in 2014. So that's 7 years ago, but the world has moved on, and Tommaso spoke about the phases on the market, and actually there are also phases in terms of regulation and the regulator and legislator are keeping up or trying to keep up. And I would agree actually with what Christina said, that I'm usually a person who would say the glass is half full. But with regard to antitrust enforcement, on the one hand, the European Commission has done a tremendous job as really being at the forefront. But as you said, it's not about the people. It's about the rules. It's about the instruments that you have. It's about the European Court of Justice looking what you're doing. So. We are, I think, now really in a phase where most of the people agree that antitrust instruments to solve both the market power and the data question as they stand are not sufficient. We have the DMA on the table, and the DMA, I think, makes the glass at least half full, although I would agree with Christina. Looking ahead, the DMA and we are working, the Commission, the Member States, the Parliament is working on having a DMA as good as it can be. But looking ahead, I think the overall approach is to have concrete rules, to have swifter enforcement than under antitrust. But what we do is actually we regulate incumbent near monopoly firms. We are not talking so much about structural topics. We are not yet really debating merger control, structural separation. I personally believe that there are sufficient forces that this will happen sometime, but the DMA is not right now taking this approach. On the DMA, let me shortly say two things. First, on the data protection question, the obligations in the Articles 5 and 6 of the DMA, so the substantive provisions and rules on what the gatekeepers are allowed to do and are not allowed to do. There are 2 or 3 provisions in it which actually right now in the Commission's first proposal dating back to December last year, more or less copy the GDPR's approach. So what they basically do is transfer what every firm has to stick to the gatekeepers. And there I would agree with Christina. We have to really think both sets of law together, but it's pretty clear for a competition lawyer or economist that, of course, for firms that have market power, rules on data combination, on the use of data can be tougher than for under horizontal data protection rules that apply to everybody. I don't know whether everybody had a chance to look into what the Parliament is about to propose. There is one provision in the Parliament's text now in it, which would make the targeted ad business really harder. And we will see how this discussion will play out, but there is some step into that direction.
Maybe is it the right place to deal with the targeted advertisement in DMA, or maybe the DSA would be the most appropriate to?
We would say it's the DMA is the right place, because the DMA is the right place because the DSA is about content. And the DMA is really about market power issues. And here we talk about, as the two outlined before, about business models, in particular of Facebook and Google, that are built. Essentially, everything is built on the targeted ad business. So to our taste, the DMA is the right place. Maybe final remark on the two already touched upon merger control. I think this is really the big question that is really not addressed by the Commission yet, neither in the DMA nor under the merger regulation. And this is, again, the European Parliament has put a provision, a proposal into its draft that under the DMA, gatekeepers can be obliged by the European Commission actually not to acquire any business at all. We think this is not a differentiated solution yet, but it at least opens the debate on having structural remedies in the DMA as well.
I have the feeling that maybe the provisions regarding killing acquisitions are not that strong and serious to make the real effect, but we'll see. I could listen to your interview for Euroactive, Tommaso, a couple of weeks ago, and you made some comments regarding the norms. We hope that at least the norms in Article 5 are self-executing. Your comment was, good luck with that.
Well, good luck with that, because we cannot tell ourselves some lies. What's going to happen is that there are already actually a large department with lots of very well-paid lawyers for the Amazon, the Google, the Apple, etc., which are preparing, hundreds of pages, and they will say, this is our report, everything is compliant, and please. And there's going to be a small department at the Commission with 80 people that will have to read all of those things. So sure, you want to have a language which is as clear as possible. That's important, but it will take time. It will take a long time, as we did in other sectors. So it's not that all of a sudden we have dealt with discrimination, we have dealt with self-preferencing. They were called in different ways in telecommunications, but it took time. It took time, and because it's going to be time is going to be needed. What I hope is going to happen, it's another debate which is happening now, who's going to be in charge of it? Is it the Commission? Is it the national regulators? Is it and I really hope, despite I understand that coordination is needed, some sort of legal certainty, but because there's going to be a huge learning phase involving very important institutional learning, I really hope that the national regulators will start their job as soon as possible. No? And I really hope that we'll, like we did in the past, there were some regulators in my field, which was telecoms a while ago. Ofcom was called Oftel in the early days. They were good regulators, and others learned from them. There was a European framework at the top, but the implementation was left. Of course, that was easier because the boundaries were national, and now the boundaries are much more difficult. But I do suspect that simply telling firms don't do that is not going to be the end of the story for sure. Because it's not going to happen. Because I'm sorry. A lawyer can tell me the language is as clear as possible, and if the law says you cannot do things, well, sure. I come from Italy, and I have a certain degree of skepticism to that.
I mean, to add to that, I mean, the notion that this is self-executing is the greatest collective delusion ever. Way you read these propositions, not treat more favorably services and product offered itself or other parties. So this is the definition of self-preference. You know, you can imagine a compliance report that says, me? Are you talking about me? I don't self-preference. That's my lawyer has written down this lovely report that says compliant. I don't self-preference. I mean, I have all sorts of objective criteria for what I do. Write in if you want to talk a bit more.
A problem there is that we need to talk seriously about the algorithm, because it's unacceptable that people that control access to 3 billion people are going to just tell you the algorithm is my property. You cannot have a look. So we need regulators to run experiments. We need this because otherwise it's going to be an impossible fight. You're going to be always coming too late when things have already happened. So we need to look at the algorithm, we need to look at the business model, because now, if you think about it, the wrong incentives come from the business model, especially Google and Facebook, because they make money from advertising. We know that advertising depends on engagement. Some people started saying that engagement is actually addiction, which is important. Obviously, people by proxy run a service experiment. They're going to tell us you got the wrong data. But there are very good people at Stanford that recently showed that about 40% of the time that people spend on Facebook is a time that people exposed regret about. Okay, they would have liked not to have spent. This is really what addiction is, right? So I regret I drank too much, but I couldn't stop, because the whole business model is made in order to make me stay as long as possible. And there are precedents about that. There is, YouTube was found showing videos about minors and their children to people which had a profile as a pedophile. They were convicted pedophiles. And again, these are horrible things. And YouTube actually fixed it, but it took time. It took time because it's in the business model to do whatever it takes to engage people so that they stay as long as possible, and then the right signal is extracted to show the ads when it is profitable to do so. And secondly, the barriers that have been, the intangible barriers which have been recreated is what I said earlier. Also in this case, I cannot know what the algorithm recommends to a pedophile because I don't have that profile, and nobody can. So it's unacceptable that people with this reach, this power, this economic power and political power just close doors to something which is really fundamental. I'm not saying they shouldn't put it in the public domain, intellectual property is important, etc. But there must be a way of actually vetting this algorithm. There must be a sensible and actually effective way of doing so.
Thorsten, maybe the same question to you regarding the self-executing norms. And now I'm thinking of Article 5 and the provision of combining data unless you give the consent. But basically, we are giving the consent all the time because the average citizen simply doesn't think of it. And we are delegating too much responsibility, obviously, to the average citizens. What's your opinion on this? Will it change something, Article 5, in the reality? Or we are going to have, again, situations in the future where, on average, abuse of dominance case took 7-8 years?
On the self-execution part of your question, I would say this Article 5A that you referred to on the data combination is maybe one of the even more of the provisions that you can, to some extent, that is relatively concrete. But second part of your question, no, we don't think as it stood in the, or stands in the Commission's proposal, that will change a lot on the issue. That's our topic in the sense of whether we would be willing to give our data away. So on that regard, there has been some discussion on whether to change Article 5A to make it stricter. And I think this is one of the topics that will now be discussed in the trilogue amongst the Commission, amongst the Parliament and the Council, the Member States. From the Commission, we know that there had been internal drafts that had been actually stricter. So I think at least in the community, there is an awareness that this provision as it stands right now in the Council text might have to be changed to have a real impact on that. Again, this is now a provision that cross-cuts through all business models. There is one in Article 6 right now that you can use specifically with regard to targeted advertisement. And at least there, as I said before, the European Parliament seems to be making a push to address those the ad-driven business models specifically.
Thank you. I'm inviting Louis Crofts to join the discussion and to supplement. Is he with us?
Yeah, I'm with you. Can you hear me?
Yeah, perfect. Thanks.
Okay, brilliant.
Thanks, Louis.
Thanks very much, Benjamin. Hi, once again, I'm sorry I can't be there.
So, Louis, take the control. What's on your thought listening to Torsten, Christina, and Tommaso?
Yeah, so Christina, I had a question for you. You talked about we've been sort of pivoting to the DMA after a period of failed antitrust. DMA is the great new hope, but is there not a risk that parts of the DMA can end up just making the problem worse? I'm thinking about, browser choice screens, choosing a browser or choosing a default search engine. People are going to just choose Google again, aren't they? It's going to just, Google or big tech companies can support the idea of increased choice now because they know they're going to get chosen. So is there a risk that DMA ends up just entrenching part of the problem?
I completely agree, Louis. I think that the genesis of the DMA, when you see the original text that then has been improved over the months, but essentially is a synopsis of current and recent competition antitrust cases you have. If you squint, you could see, oh, this is Amazon MFN. Oh, this is actually Google Android. Oh, this is Apple something or other. So there is a genesis which is effectively reproduce a synopsis of antitrust cases that we've actually failed to make a difference with. That's the bottom line. You have cases that are before the Commission. Google we discussed, there is Amazon, there is Apple, nothing is really moving for years and years, and these cases have been about data use, even about various kind of exclusionary theories of harm that actually have not delivered any change. And then we are reproducing the same categorization, the same ideas into the DMA and calling it this is ex ante regulation. How does it change what is happening now? Is the delusion that we are going to be, when you have a provision there that says you have to provide ex ante choice, this is going to be any different from what has happened in Android, in which you have the manifestation of a total failure of a remedy, in which Google has to provide indeed a choice screen, in which in fact the people who want to appear have to pay, and you pay if you're willing to pay more and appear on that list if you're a bad actor, a bad search engine who is actually monetizing that much more than others. So you have a list that is effectively one that Google monetizes from, and actually people don't pick. So what is the point? Is that going to change? Is that going to make any difference? So that's my concern. This is really nice, but whether it is going to move the dial any more than antitrust has succeeded to do, I am concerned. I think we need to think about it in different ways. We need to not just kind of, I mean, Thorsten is right. We are going to regulate the monopoly or attempt to regulate monopolies in some way. This is not going to deliver any reduction in market power. It's going to catch the really, really bad behavior. If you're beastly to some of the people on your platform, we'll try and stop you. But it's not going to disperse that power. There's going to be in 20 years the same actors, because there is no diversity. There is no sense in which, once the internet has become effectively a series of walled gardens, that anyone can really make a difference. And so, I mean, this is the conundrum we're stuck with. Unless we do something which is more creative about decentralizing and dispersing the internet, and I don't mean blockchains, but I'm really not clear what the answer is, and it isn't the DMA.
Thank you. Dear Luis, do you have another question, or maybe we can have questions from the audience?
I'll hand it to the audience. They've gone there, they've made the effort. I'm just in my spare room, so.
Okay, Johnny has a question, probably an easy question for.
Johnny should also say something about the 5A point, because I know that you feel strongly about that.
So I want to take a slightly off topic, because Tommaso opened the door to talk about the DSA, which isn't really quite on the agenda, but you were very persuasive discussing the algorithmic harm. And you had some examples, Tommaso, there that I hadn't heard of, which are particularly bad. In the DSA, almost the entirety of, I think, Chapter 3 is about notice and takedown of stuff which is made available on these platforms. But in the Commission's text, there's one single article that deals with the recommender systems that decide what you're actually going to see. One single article. In the Council's text, there's a tiny bit more. But basically what they say is these things are on by default, not off. That's a very peculiar situation we've landed ourselves in, where there doesn't seem now to be an opportunity to change that. Is there an opportunity to fix this algorithmic problem now in the DSA, or are we stuck with this problem from now on?
I'm not an expert on that. I can give you more examples, though. So another example was during the riots in January on Capitol Hill. Of course, we discussed whether Facebook was being used in order to organize all these rioters to get there. But then it's also what's very interesting is that Facebook made tons of money because they were selling targeted advertising to the rioters, selling military gear and weapons, because that was the perfect, identity of particularly weird people who like weapons and so forth. So that's an example. So what my view, because I'm more in line with competition economists, is that I believe that the companies really want to have that kind of debate happening, help us to take down bad content, okay? Help us to do that, so that, and we will work with you, etc., which means delaying, etc. And instead, it's much more fundamental for me as a computational economist, instead to dismantle the root of which is the business model, which is the power they have, the monopoly of the power they have. That's why I'm hopeful, at least, that the DMA. I want to offer some opportunities for some positive thoughts as well, and the positive thoughts. One I have, and one I am really hopeful, is, again, take the perspective that we are Europeans, and we care about our own constituencies. So our regulators, our politicians should care about our own constituencies, including our SMEs, our firms, etc. Currently, think about the current system. The current system is one where if you are a successful entrepreneur, it's a very Darwinian word, but if you're a successful entrepreneur, the best you can hope for is to be bought by one of these guys. You become incredibly rich individually, but that's great for you. But has welfare of Europe changed? No, because you've just made perhaps the ad even more targeted. If you just give more market power to an already dominant firm, they will extract even more rent. But Europe as such hasn't gained anything from that innovation. And the innovation that you have made has been an incremental innovation, certainly not drastic, or something which is a complement to the Google or the Facebook or the Amazon ecosystem. Endgame, a very rich European, and nothing changes for the rest of Europe. If anything, maybe ads become even more expensive and something, and it's even more difficult to replace the dominance of the incumbents. Instead, and this is where I'm hopeful, as we're trying to make markets more contestable with data portability, the right type of data portability, the right type of interoperability and interconnection, you will have the ambition of the European entrepreneur, whoever he or she is, in the UK, in Germany, in Italy, or in the Baltic countries. This person will be able, this company will be able to survive eventually, okay? I would add also, this is where I really think that mergers should be touched. This person should not be bought by the GAFAM, okay? And we can have a rebuttable structural presumption there, which is a very pragmatic change that would make a lot of things better. You cannot be bought, so either you can survive because you're not excluded, because you can survive through interoperability, etc., and then you can even perhaps become a player in that field, because you're not going to be dying immediately as it is happening now, because they can just copy you and so forth. This creates, I think, an ecosystem where not only European firms can survive, and I'm not thinking of the government having to fund them, etc. I believe in a separation of tasks, and the government is giving rules so that firms can survive in markets which are made ex ante more contestable through a series of articles in the DMA. And perhaps even innovation remains here, and becomes more ambitious. The direction of innovation can also change. So I would think that this is my hope. Okay, when I want to, at the end of the day, when I want to be hopeful, this is my hope that the landscape of European innovation can change for the better through the right intervention of the DMA.
Yeah, and I think that interoperability.
If you stay optimistic, Christian, please continue.
No, I mean, I sort of, I get it, I'm getting the vibe, but let's continue on that. I mean, I think I agree, interoperability amongst the provisions of the DMA is one of the most powerful. I mean, there is great writing by Dr. or others, Ian Brown, many people who write always about how this is really the sort of the foundation. If you create interoperability, if these rules are not diluted in the trilogue by those who say, oh, but interoperability is a problem for privacy, imagine that. If they're not diluted, it is, of course, powerful as a tool, because it does effectively create the potential for eliminating firm-specific economies of scale and network effects, which are really what kind of keeps you into the walled garden. And then, merger control was the great big absentee in this document, in the DMA. I mean, everyone initially was kind of aghast, but of course kind of bought this sort of the excuse, well, it isn't the right legal tool, it's Article 14, it is not something we could do. And then there's been quite serious campaigning, I think, on the part of many saying, no, we need to mention it, because the counter-narrative, which is the prevailing one, even amongst, again, economists, the profession, is this notion that, this old chestnut, I should say, that we have been prisoners for decades into this idea that if you do something like block an acquisition, then the world will end because you are committing this terminal sin of the type 1 error. You have possibly incurred a type 1 error, so you have done something that possibly was wrong, and therefore the incentives will completely perish for anyone in Silicon Valley to invent anything ever. But that isn't the case. Imagine even if you blocked 4 deals a year. Imagine if you blocked 5 deals a year. Is the animal instinct in Silicon Valley, or Silicon Glen, as they call it in the UK, going to perish? Of course not. But it is also the case that we should not, it's not the right thing to encourage entrepreneurs to think that, I mean, it's very nice for them, that I consistently create these things, and then I get 500 million, $1 billion, and then I go to the beach. That's great for you. But do we want this to be done in a way that then partakes in the profit of the monopoly? And the direction of innovation, I'm glad Tommaso mentioned it. I mean, we have people in Silicon Valley, everyone is doing an app, because the only notion of innovation that is actually going to be monetized, everyone is convinced that it's going to be monetized, is an innovation that involves data users, subscription, advertising. These are the key ingredients of every single innovation. There are gazillions of apps sitting there waiting to be bought.
And this is depressing, I think. You know? It's depressing that the only conversation we can still have now is always having the same elements into the picture, which is there is a platform, there is an app, there is consumer, and there is advertising. That's it. That's it. No one can think of anything beyond this, which is so reductive, I think. I think we are much more intelligent than this to think of alternatives. We have developed alternatives in our past as humans. No? We had, I don't know, libraries, we had squares, we had churches, we had lots of schools, and this is something instead, it's always advertising in the end, which I personally find it, I'm not an expert, but I find it extremely reductive, you know, intellectually, to keep thinking only in that, and this is something. That's why also when I'm less hopeful, also that to see all this talent which is attracted by money to these giants, which is just to reiterate this same narrative. As a human being, I think life can be so much interesting. I'm depressed again now. I'm also depressed because Lewis is not here. I've been trying to have a beer with Lewis Croft since I left the commission in September 2019. Lewis, I accepted this invitation because I saw that we were finally going to have this beer together, and now you let me down.
Are you listening to us, Lewis?
Yeah, I'm sorry. My bad.
Yeah, off record. I had another question to you, Thorsten, but maybe you could continue in the same spirit. What's on your mind? I mean, we are doing all this to have more contestable markets in Europe. And you know how important to us are small and medium-sized enterprises, etc. Is this going to change something in the mid to long term, the DMA?
It could change a bit for the better within the existing market structures, and I think the two of you have outlined it pretty well. Although I don't have like a super good overview on what SMEs in that area are doing right now, but the overall impression is indeed that there is a lot of activity geared towards an exit. Some improvements on what could fit into the Google world, into the Facebook
access to data.
If you see that as a remedy, I think I would agree. One, I think, barrier to entry to that market could be that Google and Facebook, through their market power and the investment opportunities they are able to buy the best people from the market. They have the critical mass to actually use the data. So you need the experts that are not like on the account of Google or Facebook or the others. I think that's a challenge. But you're right in that regard. I think you can be optimistic because there are access to data provisions in the DMA. We've introduced them in the German law. There will be access to data, probably laws, and also in the member states of the EU, not only under the antitrust headline, but as general provisions to increase innovation, or as Tommaso said, to have some research clause like in the DSA to give people at least the look to the possibility to monitor what the GAFAMs are doing. So in that regard, indeed, we can be optimistic. I think we can also be optimistic because the debate has changed. I mean, I remember when we wrote speeches for our ministers like 4 or 5 years ago, criticizing the Facebook WhatsApp merger, or Google DoubleClick. I saw faces in the antitrust community. How do they dare to criticize this? And I think now it's pretty much common sense that you could look into these theories of harm differently. And I think politically this has changed. If you look into the US, I mean, if you look into the Obama administration, if it's correct that Eric Schmidt was the one and only person on this globe that had immediate access to Obama, that has changed. I think that's harder for of course they are strategically important to the US government still, but that has changed. There is a debate, there is the DMA, and this is on a regulatory front, this is really progress. We can openly debate those questions. We have the DMA on the table, and that's in that regard, we can be optimistic, and the glass is half full, actually.
Can I just say, I think that what Thorsten says is important. I mean, we've had this discussion about our own continent in the main tonight, but the Overton window, as it's known, the debate in the US has changed beyond recognition in the last 2 years, really. I remember in March 2019, during ABA in DC, I did a fringe event, and Tommaso, you were there. There was an event that was titled "Are the European Leading the Way in Enforcement Against Tech?" And we were all kind of looking at these Americans and saying, eat my dust. We are so far ahead in Europe. We've done all these cases. You've done nothing since Microsoft, right? You've done absolutely nothing, 20 years of permafrost. And then you look at this today. You have Lina Khan in London, Jonathan Cantor in London. You have Tim Wu in the White House. I mean, they're there traveling for the G7. You have Tim Wu in the White House. And they're looking at us in Europe and saying, okay, now we are going to try and go fast. You have the state attorneys general suing everybody. The world has changed significantly. I'm more hopeful about what I see in the US than I ever was. I mean, I think the US is going to be, as ever, it's a transatlantic, and when it turns, it just carries a lot of weight. So I think there is significant, you know, it's a bit of a boring word, convergence, but not just that. I mean, I think these people are super motivated, and, you know, I think we'll see change.
Thank you very much. Thinking of the new German government, who has also written in the coalition agreement that going to reassess the competition framework again, my first thought was maybe we could leave the Competition Act at least alone a couple of years and see how it works. But from the academic side, Tommaso, now you can speak freely and you're not affected by yeah. What would you recommend to the German government? Again, your interview for Euractiv, where you say you need leadership. And if I ask myself, I think that we could do almost everything with the old provisions of 102 and 101, and we don't need the DMA if we want. But somebody wanted more clear language, and now we have all this discussion in the last 10 years.
Usually in conferences, there is always some person who says, but these discussions we had 50 years ago, we had 100 years ago, it's already taken care of the law. Perhaps. But then we haven't enforced the law correctly. So I think what I would say to the Germans is, first of all, wunderbar, obviously. Secondly, I would say think of resources. So sometimes you must have a resource view of organizations, because these are cases which are going to take a lot of people, are going to burn a lot of time, especially when a case is new. It will become, you know, there is a precedent value, and so you will have also on the other side people overreacting in order for that precedent not to continue. So think of that. And this is where, this may sound strange to economists, if there is an economist in the audience. The economists sometimes, we sound so reasonable, but then we say something that in practice is so nonsensical. And so we love to say every case has to be judged on its own merit. It's on a case-by-case basis that we're going. And this is the most impractical thing ever, because you cannot run every single case with infinite resources. You cannot do that. So this is where, instead, we have really to reintroduce some structural presumptions. This is where the lawyers have an advantage. That we economists said, how can you have a structural presumption against self-preferencing? You have to become a bit draconian. You have to become a bit draconian. The type 1 versus 2 error, type 2 error that Christina was saying. We went so to the extreme of doing almost nothing. So if Germans, via their own German law, can reintroduce a little bit of those structural presumptions in order to do what? In order to preserve the competitive process, which is something which is embedded in the German tradition, then you should do that, to do whatever it takes to get that principle back, because it does create more diversity. It does create an ecosystem where there is a variety of players. It does create a society where there are more views that will be expressed, where more entrepreneurship can come along. And I think you in Germany, you have these historical precedents, and I think you should retrieve some of that. So economics can help. Economics also is helpful because you need also us as academics to take a step back, reflect. We have also a collective action problem because we are individuals, we do our research, we don't have a forum where we converge and we say, well, but on balance, mergers are good, mergers are bad, but on balance, there should be a way of extracting this knowledge that we do have, but simply now our voices are not heard because you got the lobbyists, you got the consultants, and instead, in our free time, sometimes we come to the conference like this and we say thank you very much, but you don't have the academic view, which exists, and economics is much richer, academic research is much richer and interesting than sometimes it's been exposed in the policy discussion, because it's not us, it's someone else, which is telling the policymakers what economics says, typically bringing out views from the 70s, the Chicago tradition, etc. But back to your question, Pencha, I think there is a great opportunity for Germans to show leadership in order to create, to make sure that Europe is competitive. But in the way I've just said, it's not the national champion debate. You will never hear anything coming out of my mouth in favor of that. But instead, it's through making sure that the competitive process has a chance. Okay? And we gave up, especially in digital platforms, we gave up a long time ago. It's going to be difficult to catch up, but there is an opportunity now.
Thank you, Tommaso. Thorsten was listening to you. Do you have some final thoughts, Thorsten? Or
Maybe two comments on the resource question is really great because in general, my perception is that the demand in the state has risen over the last couple of years because we are used also, thanks to digital technology. I think it's a Amazonification of life in the sense of you expect politics to deliver instantly. And for example, when we have the DMA, it will cost resources, and we have to think to how to prioritize and maybe give up on other angles of policy to free these resources. And the other point Tommaso made was set the rules in a clever way that you can save to some extent resources. And indeed, it was the German competition sort of history and tradition, Ordnungspolitik and so on, of having clear-cut rules, a bit the opposite of the more economic approach to look into each and every case, into the very last detail. And indeed, we hear voices that we need to return for the sake of speed and resources to return a bit into that direction.
Structural presumptions, exactly. Christina, your final thoughts? One sentence, please.
In one sentence, very much in line. I mean, I think that we economists have not necessarily done a great deal of good to this process because there's been an initially well-meaning effort to bring structure and to bring rationality into what was enforcement blancmange, but in the end, it has ended up being too specific, too much case by case, and destroying in the process the efficiency and the speediness of it. So I would agree that we need to just...
Thank you very much. I hope we have kept the diversity of discussion. Your suggestion in the beginning, we really enjoyed a lot. But now we have to take a small break before we have the final panel for the first day, and that's the study presentation, Designing Data Trust. Many thanks.
sun to rise, lift the shadows of the night. Oh, the darkness is no friend of mine. I'm waiting on the spring to move, undo all that winters do, turning death into life and old into new. But this life has had its way, and I know I'm not the same, but I long for who I was before the change. And I'm waiting on my wounds to heal, ready for my heart to feel, and surrender my soul and drop my shield. Me convinced that there's no escaping this, and I better, yeah, I better get used to it. But I'm waiting on the sun to rise, lift the shadows of the night. Oh, the darkness is no friend of mine. Oh, the darkness is no friend of mine.
Welcome everyone back. We're just slightly past prime time, but you're in the absolute right channel, particularly those viewers online who are probably going to miss the next Tagesschau Extra on Corona. But you're going to be hearing something way more interesting now. I welcome you to a presentation and panel on designing data trusts based on a purpose-based approach. We're going to have a panel of 3 highly distinguished speakers next. Unfortunately, Ronja Kemmer, MP, won't be able to join us. But we do have a very interesting presentation to start with from Professor Luisa Specht-Riemenschneider, hello, and Professor Wolfgang Kerber. To kick us off, really. If you have ever been wondering what data trusts are, and you've been musing about this slightly fuzzy concept, then this presentation and the panel is really going to be for you. You gain an exclusive sneak peek into an upcoming study. And without further ado, I hand the floor over to you, Wolfgang and Luisa. Please enlighten us and inspire us for the upcoming discussion.
Yeah, hello, also from my side. Thank you for the kind introduction. I hope you can hear me. If you cannot, then just give me a signal. I would have loved to come to Berlin today, but unfortunately, I'm a bit sick. And Pencho, thank you so much for the opportunity to present the study remotely today. You can already see from the title of our presentation what we think must be the goal for regulating data trusts, a purpose-based approach that asks which problem a data trust should solve and regulates them in such a manner that they can really function to solve this problem. But let's start with the very basics. Wolfgang, if you would present the next slide. I'm afraid I cannot see the slide, so I depend on you doing and presenting the right slide. So I guess you might have shown it now so that we can all see. Ah, yeah, now I see the slide. Thank you very much. So please, next slide. What are data intermediaries and what are data trusts and how do they differ from each other? Data intermediaries are institutions that bring data providers and data recipients together, either by establishing direct contact between these two parties so that they can exchange data with each other. That is what I describe, or what we describe as the broker function, or by receiving data from the data provider and passing it on to the data recipient. That is what we describe as the seller function. What does data, or what do data trusts do in contrast to this? What is a data trust anyway? Next slide, please. That depends on who you ask. The definitions vary, but the different opinions agree that also their function is to mediate access to data between the data provider and the data recipients, for example, between the data subject and the company which wants to process the data. The difference between a data intermediary and a data trust is that the data trust does not act in his own interest, but in the interest of another person. He might act, for example, in the best interest of the data provider, in the best interest of the data subject, or he acts in the interest of another party according to statutes which tell him to act in this way. Hence, one can say that a data trust is a special form of a data intermediary. There are two ways to define what a data trust can be and to agree on what is necessary for its regulation. The first is to define or analyze data trusteeship on the basis of the various trustee concepts in the legal systems of the member states. So one can say our legal system requires this and that for someone to be a trustee or a trust, and now we see data intermediaries as data trusts when they meet these requirements. But if you want to find an international compromise on the regulation of data trusts or just on principles for their regulation, I think the different requirements of the different legal systems will make it very hard to go that first way. An alternative way could be to look at the cases where it seems necessary to bind the data intermediary to the interest of the data provider or to the interest of another person, and to consider all these data intermediaries as data trustees. That is what we have done. But even then, the possible data trust models differ in such a manner that each model requires specific regulation. What I want to say is, it should not be so much about the names of the phenomena we want to regulate, but about the phenomena themselves. Even if we come to call a data intermediary a data trust, that does not mean that it should be subject to the same regulatory requirements as another data intermediary that we or another jurisdiction calls a data trust. So this is our first recommendation. Avoid one-size-fits-all scenarios, one-size-fits-all solutions for data trusts. In our study, we want to show you 3 scenarios in which data trusts could be useful, and you will see that the chosen data trust model each must meet different requirements to solve the problems which occur in the 3 different scenarios. But before we proceed to these different scenarios, I want to introduce you very briefly to the 4 different basic data trust models which I have developed together with Aline Blankertz before the study and on which the study is based. Next slide, please. We first distinguish between voluntary and mandatory use of data trust and between centralized and decentralized data storage, whereby in the case of decentralized data storage, the data trust acts as a data pass-through entity, so we call it. Let me give you some examples. Personal information management systems, for example, at the moment store data in a centralized way, but they are for voluntary use at the moment. Thus, they are an optional data host. If the data would be stored in the user's wearables or their mobile phones and would only be transferred to the PIMs when the data processor asked for this data, and the PIMs forward this data to the data processor, they would act as an optional data cache. And if their use would be mandatory, for example, because their instructions need to be followed by data processors, they would be a mandatory data host or a mandatory data cache, which depends on where the data are stored again. What should these different models show you? They should show you that it would be difficult to regulate all these data trusts in the same way. If, for example, the legislator decides to make a data trust mandatory, the question arises for whom it is mandatory and what happens if it is not used despite the obligation. Each of these basic models can take on further function, for example, pseudonymization, anonymization, analyzing of data, etc. Depending on which function a data trust is allowed to perform, this in turn triggers specific regulatory requirements. Based on these different basic models, our study analyzes 3 different problems that data trusts can be considered to solve. These problems arise in the healthcare sector, in the online sector, and in the mobility sector, and I will now very briefly present the healthcare and the online sector, and then hand over to my colleague Wolfgang Körber, who will present to you the mobility sector, and who will make the concluding remarks. And I'm afraid I will need 2 more minutes than I'm allowed to speak. Next slide, please. So let us look at what is required in the healthcare sector. In the healthcare sector, we face the problem of an underuse of data for research purposes. This problem mainly results from legal uncertainty, especially in data protection law. Data protection law does not prevent data processing for research purposes. On the contrary, it allows data processing for research purposes under easier conditions than data processing for other purposes. The condition, however, is that either consent for the data processing is obtained or that a balancing of interest is in favor of the data processing. A balancing of interest always means that it cannot be predicted with certainty whether data processing will lead to a data protection breach. In case of doubt, it is therefore better to refrain from data processing. One solution could be to allow data processing in data clean rooms that meet the highest IT security standards and ensure that only research projects which are in the public interest are carried out, and that the data cannot be accessed not even by the data providers. Only the results of the data analysis are made available to the outside world. Data clean rooms should be bound to the interest of other people, for example, the data subjects and the data providers, and they are data trusts for that reason. Other opinions hold that these data clean rooms must be offered by the states, and we are open to both solutions. Next slide, please. We have 2 more requirements in the healthcare sector, which I will address only very briefly now. First, in the healthcare sector, we have lots of data already stored in different registers, but it is difficult to find these data. Hence, we need a coordinating body. Second, in several countries, we have electronic patient records, and especially in Germany, we want to allow the donation, I say donation, of this data for research purposes, and I think this is a solution we should strongly support. Next slide, please. Now, what is the problem in the online sector? In the online sector, in contrast to the healthcare sector, there is not an underuse of data, but an overuse of personal data, partly in violation of data protection law. This overuse of personal data is mainly due to an information overload of the users. No one reads data protection declarations, neither I do, but also to an enforcement deficit in data protection law. What is needed is a solution that gives us better control over our data. Personal information management systems are this solution. Data trust in form of PIMs can perform the function of a consent assistance. That means that they can give consent on behalf of the data subject according to the conditions specified in the trust agreement between the data subject and the PIMs, and transfer the data covered by the consent to the respective processor. PIMs could advise users also when it comes to terms and conditions which users do not understand. They could better communicate the information to the users and therefore help to reduce the problem of information overload. It is conceivable that they can also enforce data subjects' rights under data protection law. Next slide, please. PIMs already exist in the market, but they are not really accepted because the benefits for the data subjects are missing. To change this, we need, and this is a core message from our study, which I like to draw your attention to, which needs regulation on the system level. What does that mean? We need fundamental decisions first. We need an obligation to comply with the instructions of PIMs. Otherwise, there will never be a benefit for the users of PIMs. Second, we need interoperability standards. At the moment, however, regulation focuses on details, especially on measures to minimize risk of PIMs. We need these details too, but we must prioritize system-level regulation. I say it again because it is so important. If PIMs are to succeed, data processors must be required to comply with their instructions. Without this requirement, any regulation of PIMs is pointless because it will not lead to users taking advantage of PIMs. And one last point, there must be a decision on the possibilities and of the financing and the organization of PIMs. If PIMs are to be allowed to be offered by private parties, they must be able to operate economically. To avoid false incentives, however, they should firstly not be allowed to monetize personal data, but only services. There's no problem to monetize services. And secondly, they should not be paid by the data processors, but must be financed by the users. And in order to avoid a situation in which the use of PIMs and thus effective data and consumer protection is dependent on income, we would like to avoid this situation. Therefore, we should take a consideration of subsidy models. Thank you very much for your attention. I now hand over to Wolfgang Kerber. Thank you again.
Thank you, Luisa. Now the last case study, and this is now about mobility data. So we know that data in the mobility sector are very valuable, and there are many different types of mobility data, but I will look at a very specific one, and these are the data that are generated in connected cars. And in the future, many data will be generated in connected cars. And therefore, this is a very valuable and important data set. And the question is, what should be the governance of the data, of these data? And this goes back to a discussion we have already for some years at the European Commission. And this is a question about the extended vehicle concept of the car manufacturers, because what has happened right now is that the car manufacturers have agreed to specific governance concept for the data in connected car, which would give them exclusive control on these data. And we will see this will lead to problems. So the point is that millions and millions of car users generate these data, and there are also many firms who want to use these data for services, but also for the general data economy, and also for public institutions, for public interest, and also for research. And the problem is, how can these data be really now governed in an efficient way? The point is that the extended vehicle concept of the car manufacturers leads to the situation that all data are directly transmitted to the proprietary servers of the vehicle manufacturers, and therefore the vehicle manufacturers get exclusive control of all these data, and they have exclusive control of the access to the in-vehicle data, and also exclusive control of the technical access to the car, also the remote access. And this means that they are constructing the car as closed systems, and there is no indoor building. And this means that car manufacturers get the position of really a gatekeeper here into the whole ecosystem of connected and automated driving. And this allows these vehicle manufacturers to control all secondary markets where service providers need access to the car or to these data, and for close independent service providers and leveraging market powers to all these markets. And this has negative effects on innovation, on competition, and also on consumer choice. Therefore, already some years ago, the independent service providers and also consumer associations demanded a regulatory solution for these problems. And this is on the policy agenda of the Commission since 2016-17 already. Now, what are alternative solutions for the problem? So alternative solutions, and these solutions are discussed since 2016, so they are not new. On the one hand, the so-called shared server solution, and the shared server solution would be the same technical solution, so all data of the connected car will be transmitted to a server outside of the car, but this server will not be under the control of the vehicle manufacturers, but under the control of a neutral entity, which then can give access in a non-discriminatory way to all stakeholders, including the car manufacturers. And this would be clearly a data trustee solution, and I will come back to this. And the other solution is much more far-reaching. This is the implementation of an onboard application platform. This means open, interoperable telematics platforms, which would allow storing the data directly in the car and also would give the car owners directly the control over the data and the access to the car, so they have control about the car and the data. And both solutions would eliminate these gatekeeper positions of the vehicle manufacturers and therefore would solve these competition and innovation and consumer choice problems. And this is what's on the political agenda since 2018 and 16-17. And the Commission has commissioned a study, that's the TRL study 2017, where was clearly came the clear solution result that both solutions, the shared server and the onboard application platform, is superior to the extended vehicle concept because of these competition problems, and also the security problems can be solved with these other solutions because it's always the argument of the car manufacturers. Now, the Commission has acknowledged this problem. Since 2018, it's officially on the table for decision, and also the European Parliament has got active with a resolution in that respect. And but up to now, no policy proposal was really put on the table. Also, the Commission has several times announced, especially announcing a reform of the type approval regulation. Now, what are the discussions that are now discussed? It is on one hand a strict regulatory FRAND solution. So FRAND is fair, reasonable, and non-discriminatory access to these data of the extended vehicle. And it's not only about access to the data, but also to the car. So it's about also an interoperability solution and under FRAND conditions. And this could be done via another reform of the type approval regulation for motor vehicles. Second, the onboard application platform. This would be a very good long-term solution because it would lead to a different technological solution, which would allow really that the car owners get directly control over these data in the car, and therefore competition is directly possible. And the third solution, and this is what we thought about as a solution which is so far not so much discussed, is a data trustee solution for this. So the idea is that the legislator establishes a data trustee which gets control over all these in-vehicle data and which gets a task of giving access to these data according to the objectives defined by the legislator and certain principles, for example, also FRAND principles. And this is then for firms, this is then for public institutions, for policies in public interest, but also for research. But what is also necessary is you would still need a regulatory solution also regarding the interoperability and security, because this is necessary for all solutions. The interesting thing is with a data trust that this would gives the perspective of that all these huge amount of mobility data that will be generated through connected and automatic cars could be seen as a kind of an infrastructure now that can be used by others for innovation, and would also help for the public policy objectives and also solve these competition problems. And therefore, this would be an interesting solution. It's clear that this has to be elaborated more. We only can sketch this a bit in our study, but we think this might be an interesting further solution. Now, the last slide is only a bit summarizing here. In regard to the three examples. So in regard to healthcare, it's mostly about better and easier data sharing of personal data. In the mobility sector, it is about avoiding this data exclusivity, so this extended vehicle concept and the ensuing competition problems. And in regard to the online sector with the PIMS, it's really about getting better control about the processing of one's own personal data. Okay, thank you very much.
Thank you so much, Wolfgang and Luisa. I would like to invite you, Wolfgang, to join our panel now, and also Dr. Niels Bernsen from the Federal Ministry of for Economic Affairs and Energy. He's a lawyer by training, and he joins us from his unit, which is actually also Thorsten Käseberg's unit on competition policy, cartel law, and digitalization. You are a little bit of, well, the competition policy guy, you told me, coming, well, straight from the engine room. So we do hope we can give those kind of concepts and characterizations that we just heard in the presentation a little bit of a reality and maybe practice kind of check. I should have also really introduced to you Wolfgang Kerber and Luisa Specht-Riemenschneider properly, which I've forgotten, shame on me. But I will briefly do that. So Luisa Specht-Riemenschneider, as you may have guessed, she's a lawyer. She's a professor at the University of Bonn for civil law and information and data law. And she's also a director of research, director of the Research Center for New Technologies and Data Law at the University of Bonn. What I find interesting is actually her most recent also position that she holds among many. She's a board member of the OECD's Consumer Policy Advisory Group on Dark Patterns. That's an interesting one. And Wolfgang Kerber, he's a professor for economics at the University of Marburg. One interesting bit in your career I found a very long time ago is that you were once the director of the Walter Eucken Institute in Freiburg. Anyone who knows the history of German order liberalism will have heard of Walter Eucken, and the Walter Eucken Institute is one of the guardians of that heritage. And keeping with that, he's got a strong interest in competition policy, intellectual property, research, and any kind of research at the crossroads of law, economics, and political science. Before we kick off our questions, I should say one more thing. There will be space for audience questions, so please do think about questions. Make yourself known or heard, raise your hand, and I will try to get to you as soon as possible. Maybe to kick us off, I would like to start with a really broad question. I'm going to come up here. To you, Niels. So what you heard in terms of the characterizations about, different types or categories and maybe also sectoral applications of data trusts. In your practical work, does that kind of ring a bell? Does it make sense, or what is your reflection on that?
Yes, many thanks for having me. It's an interesting one because, as you said, I'm working in the competition bubble, if you want to say so, and competition law, as you know, is horizontal. So we are aware of the problems of bringing things together from various angles and various sectors. And what you see very good in the study, I think, is that we're talking about very different things here. And it's very difficult to find the common denominator here to say, like, is there really the one data trust or the one data intermediary solution which will be the one-size-fits-all approach. Probably not. I think the authors of the studies share the same opinion, but I think that, yeah, that clearly does ring a bell. Like speaking from my experience from the engine room, as you said.
Thank you. You were highlighting something that Louisa has been highlighting as well, in a way, that there is, of course, kind of a challenge in regulating either data trusts or regulating for data trusts, in that you need sort of to some degree a horizontal approach. You can only do that, however, to a certain level, because as soon as you get into the specifics of certain applications, you will necessarily get down into sectoral law solutions and thoughts. Now, Louisa, I would like to ask you, in going back to that kind of thought, isn't there a risk then that you end up again with a highly specialized set of regulations and special cases that are so fragmented that, of course, you cannot have a one-size-fits-all solution, but too much fragmentation isn't really helpful either. So I do wonder if there is a need for sectoral specific and therefore somewhat fragmented legislation. Are there still some, cross-sectoral kind of lessons learned that you could draw from your sectoral studies, even if it's only the kind of questions that regulations would need to answer?
I'm skeptical on the horizontal approach of regulating data trust. The takeaway is here: avoid one-size-fits-all solution, but maybe we can agree on, well, we need to look at the problems we want to solve. There could be a horizontal takeaway, but this horizontal takeaway will end up in sector-specific regulation. And I'm not sure if I agree on your opinion that sector-specific regulation is no good. I don't think we have any problems with this sector-specific regulation as long as it solves problems which occur only in this sector and which are very, very specific. And I think data trusts are are part of a solution which always is very, very specific. So yeah, our study and I'm personally quite skeptical as to whether this really requires horizontal guidelines and if horizontal guidelines would really be beneficial here.
Okay. Yes, of course, Wolfgang.
I think this is a very important question, and I think there's always a trade-off between horizontal and sectoral solutions. And the problem is, and I think this is also what you alluded to, that we cannot all problems solve with a sectoral solution. This is also not possible. Yeah. So in that respect, we also have to have a step-by-step approach. But I think what's important is that we look at specific problems which are very clear, but also which are large clear. I think the data in connected car is a good example for this. And look what specific problems is there, and can we find a sectoral solution? And it's very clear we already have a sectoral solution from the past here, and therefore this might be a good idea here. But it's also clear that we cannot do this with all specific problems. So in that respect, this problem still exists, and we have to deal with it. And what we can do in any case is we can really learn from different solutions, also for the sectoral solution. I think this we can do in any case. Yeah, but it's a problem which cannot entirely solved. I agree.
Okay. Maybe just another thing I want to dig on deeper, or dig into deeper. If you certainly one thing that thinking about sectoral approaches helps us to do is to think about the previous examples, the previous cases where you have solved a problem that exists, and also where we have made already effectively political, maybe also societal choices in favor one solution over another, in favor of, let's say, competition over concentration. How would you say does that relate to your example, for example, in the mobility sector, and maybe also in other sectors?
I mean, if we look at this connected car example, this is a very specific example, I agree. On the other hand, behind this, it's a smart device, a connected car. So in that respect, it is only an example for an IoT problem. And we have similar problems also for other smart devices. So what we see in nearly all smart devices is that the manufacturer of the device usually wants to get all the data and exclusive control of the data that the device is producing. Also, the users are generating the data. Yeah, and this we see very prominently in smart agriculture, in the agricultural sector, where this is also much discussed, the problem that manufacturers of the smart farm machinery collect metadata, and the manufacturers have the data and not the farmers, and this has been discussed as a huge problem. But we also see this with other smart devices. So in that respect, this problem is in different IoT contexts, but might then also have different aspects. So for example, in the example of smart agriculture, it is a farmer who is working with this, is not a consumer. So, yeah, and therefore there are differences, and then we have to think about what does this mean.
Yes, please.
Maybe if I can jump in on that point, because competition might be one of the links between the sectors and the sector-specific cases. And we see, I think, yes, there are familiar problems in several sectors, and of course, it's not everywhere a completely new problem. But still, if you look at the sectors, well, and if you focus on competition only, by the way, I think one point where the study is very clear and very helpful is in its finding, be very specific about the purpose of designing the data trust or designing the tool, whatever. It helps to build you an efficient tool. That's something which is really helpful for our work, of course, as well. But even if you do that, and if you focus only on the competition side of the problem, and if you take only one sector, for example, the vehicle data, even then you have several layers. I mean, I think the sector study is very clear and very helpful. And you can see very well that you're not only talking about the competition between the OEMs and the aftermarkets, you're not only talking about the competition relation between OEMs and users, you're also talking about big tech and OEMs. And their a solution like a data trust or data access rights or whatever can help for a particular level of this competition problem, but be detrimental on the other level. For example, if you open up the data and it, in the end, aggravates the problem of market concentration because the data you have opened up by that right to access to data ends up with a big tech or with the dominant player, even if it's not big tech, then you might found a solution to the one level, but not to the other. So jumping back to your question, it's very difficult to extrapolate from one case study to the other.
Maybe bringing on that topic of what's the sort of complementary instruments and tools that needs to be applied to make data trust really work. Bringing in back Louisa, you alluded at one point, I think it was in the PIMS example, that a data trust in a way is only ever, it can only help to solve problems really if it is applied together with other instruments. I think you mentioned interoperability, and can you maybe explain or explore that thought a little bit further?
Yeah, of course. I think one big misunderstanding in the current discussion is that data trustees are called the one and only solution for many problems. But they are neither the one and only solution for many problems, nor are they the solution. They are only part of a solution. They are always only part of a solution, and they must be accompanied by other measures. And we mentioned in our study that this could be interoperability standards, or always, or not always, but mostly are interoperability standards. And could also be, for example, data access rights. And why is that the case? Because the data trust is always the infrastructure, and the best infrastructure does not help if data sharing does not work because no one wants to share the data. So if we get to the problem that this is the case, and we want to make the data being shared, then we need data access rights. But this is only one example of of a measure which could accompany the data trust solution. What is important is that the data trust is not the solution itself, but can only be part of a solution and must be accompanied by different other measures.
Yes, you want to react to that, Wolfgang?
Yeah, I would like to add a bit in that sense that what's very important is that you always start with the problem that it has to be solved. So what is the problem that should be solved? And what are then the purposes of this? And then ask what you need. And then the point is the data trust might be a solution, but then in order that you really have an effective solution, you might need to complement this with other regulations. So I think a very good example is the Second Payment Service Directive, so the PSD2. So PSD2 is really a very complex regulation. You have on one hand, you have a data access regulation. Yeah. On the other hand, you also have really a regulation in regard to security, and you have a regulation with interoperability, and you have a fee regulation. And you have a special regulator about this. So you have a whole complex of regulation, and only the combination of all these regulations can make this effective. And if one is missing, it will not work. And I think this always has to thought about what really do you need for solving a problem. So you have always start with a problem, and then data trust can be a solution. But the question is, what do you need else? And this can be different.
Yes, please.
No, I just wanted to underline that like within the competition bubble, we have discussed data access right quite a lot. We have discussed interoperability, and we are still discussing it in the DMA. Data trust, no, not yet. I haven't heard that so much, but that they could have a potential. Where exactly, again, you have to be specific. It could be a solution to the problem that when you have a data access right under competition law, for example, or sector specific, but then you have a conflicting right of a third party, for example, because the data you want to access is personal data, or because it's a business secret. And then data trust could provide a technical solution to that problem that you have conflicting interests of like an access right on the one hand and a right of the data to be protected on the other side. On a regulatory level, that's often not, there's no solution to that. We find, if you look at the regulation, then you find clauses such as without prejudice to the GDPR or without prejudice to this and that regulation. But the conflict itself is rarely solved. And this is where data trust could come in as a technical solution. And then jumping back to the competition policy level, that, of course, is interesting because you could open up data for competition and mobilize data for competition without having to lower the level of protection of such data. So that's where the competition angle comes in. But again, that's only one piece of the puzzle, of course.
We do have a first question.
Let me please just very quickly jump in and support that. This is a very important possible function of a data trustee, just harmonizing the conflicting rights, or even maybe lowering competition risk because you can just process data in a secure space and no data just goes out. Yeah, this may lower competition problems.
Thank you, Louisa. We do have a first question from the audience, please.
Oh, is it working? Ah, it's working.
Now it's working.
Amazing. So first of all, thanks. It's super interesting for me to listen to what you're talking about. I'm Damien Bislager. I'm a member of the European Parliament, and yesterday night we finished the negotiation of the Data Governance Act, and so we had a horizontal approach to data intermediaries, as Louisa also very well knows, and so I will try to defend this kind of horizontal approach because there was a bit of a question whether you have to go sectoral and horizontal, and I do believe that learning from the different problems can then maybe help you understand the horizontal level a bit better. But I mean, if I look at the different case studies that you presented, I think we have to understand that there's a different level of sophistication of regulation when it comes to personal and non-personal data. Because for personal data, obviously, we have already established with GDPR that, you know, somehow the end user, or whatever you want to call him, is in, or her, is in charge of that. And then the question is, how can you give meaningful control and access to this end user to actually execute that right? So that's a tool of data trusts can help to actually help them, you know, be meaningful in the execution of that right. But in the cases of IoT and Internet of Things and, you know, end users when it comes to cars or farm equipment or whatever it is, we don't have that regulated yet. And so I believe that there is a horizontal need to regulate, you know, who has meaningful access and should have meaningful access and control over the data that they're producing. And it's a bit of a principled question, and that's why I think there is a bit of a horizontal need, especially because obviously you have to weigh, you know, the production process of the data when you're actually using the car versus the effort to create the software that then will actually, you know, generate this data, and, you know, the incentives need to be clear. But I think there is the question of how we do that, and then we can think about the more horizontal, so the more vertical solutions, and also more the tools that then make this meaningful with data trust and so on. So I was just wondering whether you could react to this question of we still need a horizontal approach when it comes to non-personal data.
Thank you. And I guess also how you rate that opportunity for learning spillovers in other sectors. I'm not sure who wants to react. I guess maybe Louisa, and yeah.
Yeah, maybe just very quickly. Thank you very much, Damien. You know that I'm not very happy with the Data Governance Act, as it also regulates PIMs. I'm kind of happy with it for big data intermediaries, but we talked about that before. Let me just very quickly correspond to two aspects you spoke of. First is personal data is regulated in the GDPR and not in the Data Governance Act. I think that's exactly the problem, that the GDPR isn't opened up, and GDPR and Data Governance Act are not thought of together. The second point is, do we need horizontal regulation for non-personal data? I'm not sure. Maybe, Wolfgang, this is better for you to answer. Maybe, yeah, out of competition reasons, that might be a point, but not for data trusts, maybe more for data intermediaries.
Perhaps I can step in here. I mean, data are non-rivalrous, meaning that many firms can use the same data. And this is a problem, because this is a chance. This is very good, but it's also a problem, because this leads to the consequence that any solution where one party has exclusive control over these data might be a problem. And this is exactly what we have here in the connected car example, where the car manufacturers get exclusive control over the data, and this leads to problems. Now, there was already a proposal for a horizontal solution for exactly for smart devices, and this was a proposal for a data producer right in 2017 of the European Commission in this communication building a European data economy. And they made this proposal exactly for smart devices. And they said that the owners or users of a smart device should have exclusive control over these data. This was a proposal. This was data producer right. And this then did not really, was a lot of resistance against this, also sometimes of good arguments. But this a bit this experience, so this was already something. And the problem is really that with data, we should more think about not that one entity should have exclusive rights, but that this is something which many can use. I have this called, in one of my articles, a multi-stakeholder problem, yeah, where there are several who can use the Jaeger, and then we should have perhaps also rights of different stakeholders or of many stakeholders using the same data. And this is on an extreme form. This is open data. Open data is that anybody can use it. It's an extreme form. But in a less extreme form, it could also be that you take exactly this idea of a data trust, where you put the data in, and then someone, the legislator, decides which groups should get, under which conditions, what kind of access to this data. And this then can be used, for example, for training algorithms. This is anonymized data sets, yeah, and or opening certain kinds of data sets really for new startups, etc. And then you do not have that one entity has exclusive controls. This is a problem with the data. And this is different for personal data, because the personal data we think, okay, the person should have this right. This is different. But for non-personal data, it is not the case. And therefore, I think it's from that perspective also data trust might be an interesting solution, at least for certain kind of data sets.
Thank you. Yes, Niels.
I wanted to add one other aspect, and we haven't discussed this yet, but I know you're aware of that, and I know that you're doing a tremendous job in designing the Data Governance Act, and it's really great work. But I think there are two elephants in the room, and I think you are aware of it. But the two questions are: who's going to do it? We're talking about a market which is not developed yet. You have actors in the market, but quite a few. They are not as big as people want them to have. And the second one is, who's going to do it? Like, who has the incentive to do that? We heard a bit about that in the study. Of course, there are different models. Of course, you can think about various things. But the question is, if you try to regulate that market before it has really developed, you can do that. Maybe that's a smart idea, to develop a market by regulation, if you want to say so. If the central problem is lack of trust, maybe that could be the solution. But the incentives are so various in the sectors that there is a potential risk, I would say, that's my personal opinion, I'm not speaking for the ministry there, that you cannot catch the incentives correctly, and you might end up with a design which creates, like, oversimplifies or like destroys incentives at a point where you might need them for actors to come in and to develop those solutions, which we all hope to have soon.
Thank you so much. Maybe we can just have a very brief closing round, because that, I think what you just said, we are really at the conception kind of stage. We are at the initial development phase of potentially a new market. Brings us to what I would like to ask you as a closing question, and maybe we can start with Wolfgang. So we've just heard from Niels that this market, it's all not really developed yet. We don't know where it's going yet. Let's say we meet again in 5 years and we sit here. What will data trusts have done for the world?
I mean, this depends very much whether really data trusts are developed. And therefore, I'm so far a bit skeptical about this, because I do not see really that the preconditions for data trusts are really here so far. We have seen the PIMS, so I think we need really preconditions on the systems level. And with interoperability and with this obligation to really cooperate with these PIMs. And if we don't have this, then I think we will not get a market for this. And therefore, this has to be done. And I think this is really also a task really of the regulator, of the legislator here, to set really this right framework of rules. And we've talked about this for enabling this.
Louisa, I guess you would agree with the PIMS bit, but are you as skeptical?
No, I would very much agree to what Wolfgang just said. Let's not only think about the risk of data trustees and especially of PIMS. Let's see how they can help us, and they can tremendously help us. And then let's accompany the measures to minimize risks by measures which give incentives for the creation of PIMS, for the functioning of PIMS, and yeah, let's enable them to solve the problems we want them to solve.
Niels, I guess you feel the burden of expectations. Where do you want to go with that in the next 5 years?
Well, we're talking about hopes here, right? So I hope in 5 years when we meet again that We see successful stories of data trusted or data intermediaries in various sectors, and I hope that they play a vital role in solving the problem they were designed for. Let it be data protection, let it be control of my personal data, let it be competition. Maybe the purposes can join, and you have data trustees which solve several problems at a time even better. But I hope that would be my hope, that at least we find successful stories in 5 years.
Thank you so much. Thank you very much for the insightful presentation and the really interesting panel. I guess at some point in the new year, everyone will get to read the new study on designing data trusts. Until then, I think Pencho has got a very honorable task to do.
Thank you. The late night show goes to end. European Data Summit, day 1st. As promised, we are going to deliver the paper in the beginning of January. Earlier wasn't possible, and we really congratulate the European Parliament for the great job with the Data Governance Act. We are looking for the incentives still, and we're going to discuss it tomorrow with you again. Now, I would like to remind you that we're going to start tomorrow at 8:45. Don't miss the unintended consequences of the GDPR with Winfried Weil. And we have many more interesting speakers. Just to mention a couple of them: Audrey Tang, Gary Davis, and we would like to move also from strategy to execution when it comes to data sovereignty. So we're glad to see you tomorrow again. And now we are inviting you for a glass of wine. Many thanks.